with the consent of the applicant, I beg to mention item number 55. Madam, we've taken a next week, madam.
Item 55.
My friend is the applicant, madam.
Aye.
Aye, madam.
Okay, on request made by Mr. S. Bora, Leonard Standing Council,
VTC, madam.
PTC, please the matter after,
After we.
afterward.
May I please, your lordship? Lordship, in item number 66, lordship, Lordship, Paras matter was remembered, lordship. IIT matter, lordship. Lordship, in this matter, Standing Council IIT has filed a affidavit, lordship. That may be bring on record, lordship, and matter may be taken up at 2, lordship.
We'll see. We'll call for the affidavit, but you wait, I'm not fixing it.
Otherwise, lordship, matter will left over.
If it doesn't need, then we'll upgrade.
Lordship, deeply obliged, lordship.
May I please, your lordship?
Oh.
Lordship, I beg to mention for listing of a matter, my lord, that for admission, my lord. It was listed on last 2/1/23, my lord. Therefore, not listed, my lord. On Wednesday, my lord. Relating to result, my lord. This case is relating to result, not being by the Guwahati University, my lord.
Well,
Obliged, my lord.
Wait, please, your lordship. Lordship, I beg to mention item number 50. This matter may be become infractuous, lordship.
item,
Item 50.
your good name, please.
Z. Bora on behalf of Mr. M. Bhagavati.
M.
Bhagavati.
Item 50.
Lordship.
Okay, MS.
Z. Bora.
G. Bora, Leonard Standing Council, Leonard Council, appearing on behalf of Mr. M. Bhagavati, Leonard Council for the submits that the matter has become in practice. Who appears secretary?
I'm
MS B. Das, Leonard Standing Council, appears for the secretary judicial department. Writ petition is accordingly disposed of as infractions.
Lordship. Kindly oblige.
May I please,
Deeply
Lord?
oblige.
Lord, I beg to mention for a listing of a contempt matter.
Oh,
Can it be on 10?
14.
Of like,
Wait, please, madam. So, with the consent of the petitioners, my lord, I beg to mention item number 41 to 46. We are expecting the original records today, madam. Lordship will kindly take up this matter after 2 weeks.
41 to,
46 minutes.
have you taken the consent from
Yes,
the?
madam.
My lord, we are here, but
Lordship, a date may be fixed.
Adjournment, let it go on 13/6.
13/6, lord.
13/6 can be fixed better.
My lord.
41 to 46 on request made by Mr. B. Kaushik. Leonard Standing Council,
Elementary.
Elementary University Park. List the matter, when do you want?
13/6.
30.
Obliged, lordship.
Grateful, madam.
Please, your lordship. I beg to mention for listing motion matter, your lordship. Filing on 22/5/2024, your lordship. Monday or Tuesday, your lordship.
What is the urgency?
Agency, your lordship, similar situated person getting for interim by this honorable court, your lordship. Matter relates to defam or befam students, your lordship.
Oh.
Lordship filed on 25/2024, your lordship.
Okay, 5th.
May I please, lordship? I beg to mention item number 5, 6, and 7, my lord. In this case, I have to file implement petition, my lord. Finally, 2 weeks will be granted.
5,
6 and 7.
these are all different matters.
My lord, on-time matters, my lord.
Contempt case,
Yes,
DP Chalia is there?
no, my lord. Sorry, my lord. Sorry. It's not for this court. Obliged. Sorry.
May I please, lordship. With concern other side, my lord. I beg to mention item number 52, my lord.
Yes.
This case may be listed after 2 weeks, my lord.
Your good name?
Yes, Islam, my lord.
On request made by Islam and Council for Petitioner. List after 2 weeks.
Hello.
Right, Mr. Lordship, followed with the consent of the petitioner, I'd like to mention for item 14, Lordship.
Item
14,
1/4.
yes, Lordship.
Yes.
My lord may kindly fix the matter after 10 days.
I am for the petition on my lord. I have no objection, my lord. I was surprised.
Your good name?
M.A.I. Hussain.
Third M.A.I. Hussain, learned counsel for the petition. On request made on behalf of Mr. Ardar,
Yes, sir.
learned standing counsel,
Tribal affairs.
WPT and BC. Please the matter after 2 weeks.
May I please, your lordship, I'd like to mention for listing of an admission matter, my lord.
Yes,
Any date next week if possible, my lord.
next week will be difficult.
Any date, my lord.
12th.
Highly obliged.
May it please your lordship, with regard to item number 19, my lord.
Hmm.
I'm for the respondent Borland University, my lord.
Hmm.
My lord, some difficulties of my senior, my lord. I have taken consent of the petitioner, my lord. The matter may come up 2 weeks.
You have 40,
Respondent Borland University.
Boroland,
Borland University.
you are the standing counsel.
Lordship.
Okay, on request made by Mr.
B.K. Borua.
B.K.
B.K. Borua.
Barwa, learned standing counsel,
Borland University.
Boroland University. Please the matter after
2 weeks.
2 weeks.
May it please your lordship, my lord. My lord, with the concern of the other side, my lord, I beg to mention item number 59, my lord.
Yes,
My lord, we have some personal difficulties today, my lord. Let the matter may come, my lord, after a week, my lord.
you are for the petitioner.
Petitioner, my lord.
Your good name?
H.P. Gwala, my lord.
On request made by HP Bala, learned counsel. Please after
1 week, my lord.
1 week.
Oblige, my lord.
May I please your lordship?
Mm.
Lordship, I pray for listing of an admission matter. Lordship, that may come as per your lordship's convenience.
Admission matter,
Yes.
okay. 19,
Obliged to.
May I please, your lordship, I beg to mention item number 54 from the daily list with the consent of the other side. As my senior is out of station for adjournment of the matter, I'd like to list it after 3 weeks.
who's your senior?
Senior advocate Jyotirmoy Roy.
On request made on behalf of Mr. J. Roy. Then senior counsel for the petition. List
After 3 weeks.
3 weeks.
May I pray, my lord,
What's
for
up?
listing for withdrawal, my lord, at 2 p.m. my lord. Lordship.
Why?
My lord, some, I have filed an IA, my lord, which is defective, my lord, some error is there. So I will file a fresh, my lord. IA is already registered. So on Monday or if possible,
Monday.
Monday.
May I please, your lordship. Lordship, I pray for listing a pending matter for admission. Lordship, as your convenience. That
Yeah.
may,
Okay. 19.
lordship, deeply obliged.
Lordship, in item 54, he has mentioned, Lordship, that date may be fixed, Lordship.
After 3 weeks, it will come up.
Lordship,
Let it come up.
deeply obliged.
So, Lordships, with the consent of other side, my lord, item number 12, my lord. Item 12, my lord. Let the matter be listed after week, my lord.
Item 12. You have 40
Applicant, respondent, my lord.
applicant.
Yes, my lord.
Your good name?
M. Sunil.
Okay, on request made by Mr. M. Hussain, learned counsel for the applicant. List
Hello.
after,
Interim order, my lord.
My lord, after 1 week.
after 1 week. Interim order passed in the main petition to continue till the next.
Obliged.
Item 1 of daily list. Motion.
May I please, your lordship. In this case, SRG was asked to obtain certain instructions by the last order.
But it has been listed after more than a year, my lord.
Yes.
I will get the instruction. And
I thought-
the order is dated 2nd November 2022, was filed in 23 and after a year it has come.
You have no instructions till now.
No, my lord, it has come after quite a long time. It is listed after 10 days, but in the meantime, I will get the instruction.
Okay, heard Mr. D.B. Chalia, the senior counsel for the petition. On request made by S. Bora, the standing counsel,
CRT.
SCRT. List the matter after 2 weeks to enable him to receive.
To
May please, your lordship. First of all, in this matter, we have received our instruction. 2 weeks time may be granted.
You find
If you repeat in opposition.
this will require some hearing.
Yes.
Don't will issue notice,
Yes.
but MS,
Lordship,
your good name,
I am from the petitioner lordship.
your name,
P Dekan.
MS B Dekal and council.
Date may be fixed, lordship.
Issue notice. Secretary who appears,
I am April.
MSP does. then
Correspondent 1, 2, and 5.
Secretary Education. Yes, correspondence 1, 2, and
Five.
5. And Mr.
She Sharma, lordship.
C. Sharma, then standing council,
Yes, lordship.
Imasu,
Yes, lordship.
autonomous council. Appears for the respondents, 3
Three.
and 4.
3, 4, and 5, lordship.
You are appearing for 5 for,
5, 2. Then your lordship 1 and 2, your lordship.
we'll make it 1 and 3, 4, and 5.
Inspector of history. Oh, he's a demand, sir.
Notice and respondents are complete.
Retired.
Mr.
She Sharma, lordship.
C. Sharma, then standing council. Dimasu autonomous council. Submits that he has already received instructions. And prays for
2 weeks time, lordship.
2 weeks time to file for that.
Date may be fixed, lordship.
Praise the Lord. Please the matter of 21st.
Deeply aware.
3,
Applied, lordship.
3.
So, Lordship has passed a similar order. Okay, sending the case to the government of Assam.
Instruction on this?
What is this case?
Yes, any.
Amalgamation, my lord. As per clause, as per the clause 19, your lordship in the earlier case, my lord has directed us to file an appeal.
To office member.
The same case, lordship. Only in this case, there is no question of road. Yeah, they have violated the clause 11 of the memorandum, my lord. In the memorandum, lordship,
Where's the memorandum?
yes, my lord. Yes.
Clause 11, what is this?
My lord, this is clause 11, may be kindly seen, my lord. 11. To optimize the use of services teachers in a 2-class high school on nearby ME school, having poor enrollment, that is less than 35 students in each class, may be merged with the high school. In our school, there are more than 224 students.
200?
My lord, I have made the statement in paragraph. Paragraph at page 65. Page 65 may be seen, my lord.
Yes.
There are more than 224 students.
Where's the order that you agree with?
My lord, that's the impugn order at page, my lord, 22.
Where's your school?
My lord,
Where's your school?
my lord, just
Serial number 33.
Page 23.
Page 23, serial number
serial number
33.
33, ho na? 33, page Page 23,
Please query.
serial number 33, my lord. Anshalik Milan Higher Secondary School. And the next is Milan MEM School. Next MEM school, my lord, has been amalgamated with the high school. In spite of having more than 200 students in the school, and the school, there will be a overwhelming number of students in the high school. So if there is less than, my lord, 35 students in each class. So, my lord, the number is very much high.
Your school is
My lord, page 23, serial number 33,
Milan,
Milan MEM School.
Kasimpur.
Kasimpur.
That's your school.
Milan MEM School.
We can dispose it of.
My lord can dispose it of. In fact, my lord,
Have you made any representation?
My lord, we have
Have you
submitted
filed any
petition.
appeal?
Yes, Lordship, we have annexed it also. Lordship, we have page. Page 65. We have, we'll file a regular appeal as per this provision. As per this clause 90.
Heard Mr. R.C. Saike, learned counsel for the petition. Also heard Mr. B. Kaushik, learned standing counsel,
here I am appearing for the elementary. My lord.
Elementary Education Department. For all the respondents,
My lord, elementary and secondary both are there. My learned friend will appear for secondary. My lord.
elementary will be respondent 1,
Respondent 1, 2, and 6. My lord.
2 is secondary,
2 is secondary. Yes, that's right.
respondent 1, 4 and 6.
1, 4, 6.
And MSB does, learned standing counsel, secondary
2,
education.
3, 5.
235.
For the respondents, 2, 3. Stop. Para. The petitioners in the present writ petition are the president and the secretary of the school managing committee of Milan MEM Kasimpur School in the district of Nalbari. Stop. They are aggrieved with the order dated 24/7/2023 issued by the Director Secretary Education Assam, by which their school, i.e. Milan MEM Kasimpur, has been merged amalgamated with the Anchalik Milan Higher
Higher
Secondary
Secondary School.
Kasimpur.
Kasimpur.
Stop. Para. It is the case of the petitioners that in terms of clause 11 of the office memorandum dated 3rd August 2021 issued by the Secondary Education Department, Government of Assam. One nearby ME school having 4 enrolled, by the Government of Assam, that to optimize the use of services of teachers of a 2-class high school, comma, one nearby ME school having 4 enrolled, i.e. less than 35 students in each class, may be merged with the high school. Stop. However, comma, the school of the petitioners has an enrollment of more than 224 students. And therefore, the amalgamation of the petitioner school with the Anchalik Milan Higher Secondary Kasimpur is not in terms of clause 11 of the OM dated 3rd August 2020. Para. The petitioners have also made a representation before the district education officer Nalbari on 9/8/2023 for cancellation of the order of amalgamation. Stop. Para. Clause 19, is it?
Clause 19.
19,
19
19.
of the OM dated 3rd August 2021 provides that for any disputes arising out of the order. Oh, no. Cancel. Clause 19 of the OM dated 3rd August 2021 provides that the director concerned will issue necessary order for amalgamation. And for any disputes arising out of the order, the aggrieved institution of the public may appeal before the government in the secondary or elementary education department as the case may be. Therefore, stop it. Para. A perusal of the representation dated 9/8/2023 indicates would indicate that the petitioners are approached the wrong forum. Stop. Para. Accordingly, after hearing the learned counsel for the parties, this present petition is disposed of, directing the petitioners to file an appeal in terms of clause 9 of the office memorandum dated 3rd August 2021 before the government in the secondary education or elementary education department, as the case may be, within a period of
3 weeks, my lord.
within a period of 3 weeks from today. Stop. Thereafter, on receipt of the appeal, the government in the secondary education or elementary education shall dispose of the appeal in accordance with law by a speaking order within a period of
6 weeks, my lord.
within a period of 6 weeks from the date of receipt of the appeal. With the above observation.
Please, my lord, status quo order, interim order will continue, my lord.
Interim is there?
Yes, my status quo order is there.
Okay, then say like this, the interim order of status quo passed on 13/9/2023 shall remain in force till the appeal is disposed of by the government. Stop.
Oblige,
With the above observations and directions.
oblige, lordship.
May I please, your lordship? Just one time petition, the court direction, lordship, page 40, lordship,
Page
40. The common judgment, lordship. Para 19.
Have you served a copy?
Lordship.
Have you served copies?
Lordship.
Where is that?
Page 11, lordship.
When did you serve?
28/4/2023, lordship.
Page 11?
Page 11.
Page 11 is the judgment.
Lordship, in the receipt copy, lordship, I have annexed it there. The office has endorsed,
Where?
on left side, Lordship. And bottom letter. And respondent number 2 also,
You just produce a copy of this order.
Lordship. Serve the copy, Lordship.
You just served a copy of the order, nothing else.
No, Lordship. The court direction is, Lordship, the only the serve the copy, Lordship.
Huh, You should have served it with a letter.
Lordship, that the only copy I served, Lordship. And go as per court direction, Lordship.
Who received this?
The court cell, Lordship, in page 11, 11A, annexure 2, Lordship, can you see? There also receipt endorsement by the office, Lordship, the office of the respondent number 1.
Where's annexure 2?
Page 11A, Lordship. And on the C cell, Lordship, that means court cell. Court cell number 379.
How do we know that the respondents have received your copy?
That is their endorsement, Lordship.
Maybe the endorsement is registered by the sale only. You're supposed to serve it to the concerned authority.
Lordship.
Have you served copies? Have you served copy to the director?
Lordship, this is the director office, Lordship. The endorsement was given by the office of the director, Lordship.
Or do not run responsibility? Issue notice. Petitioner protected for service of notice. Also responded 1 and 2 by registered post ID. List of the 6 units.
Lordship.
But PC not.
This is an application for contempt, for non-compliance of the order of the honorable court for release of the salary.
Where's the order?
Order, you'll also be find that. Hmm? Hmm? 14. Page 14. Hmm? Page 14 of us. 25 of them. At page 20, 23, 24, you're also find the upper report order of the land single judge.
When did you serve copy?
I served the copy, my lord, on 19 February 24. Against that, my lord, there was an appeal. That appeal was also dismissed.
Oh.
And after that, my lord, I find the application, my lord, annexure F, page 33, to the Director of Inventory Education. Along with all the copies, my lord, I have furnished. Page 33.
So what is your case? This writ petition was dismissed.
Dismissed, my lord.
Oh.
It was against us
Oh.
because our services were provincialized. And since as the petition was pending, although we joined Milord, we are not paid salaries since appointment. And after this dismissal, Milord, after the dismissal of the writ, Milord, we filed this application since it has been allowed against us for release of the salary. But the director has not passed any order, Milord. We personally also met petitioners.
Then you have to file a writ petition, not a contempt.
It is a non-compliance, Milord.
Non-compliance, what non-compliance? Here only the writ petition was dismissed.
Yes, our orders were stayed there. It was against,
That's why.
our
There's
provincialization
no
orders were
direction,
stayed.
there is no direction to the respondents to release your salaries.
Let's say, Milord, at page 24.
Yes.
In view of the above, the court does not find any ground to set such an inquiry report submitted by the petitioner. Consequently, the prayer of petitioner setting aside the provincialization order, that is against us, Milord, and for provincialization of services of petitioners being without any basis, there is no ground for this court to exercise in discretion.
Is there a direction that they should release your salary?
No,
You file a writ petition.
our, that was stayed, Milord.
That was stayed, there's no
Our
issue on
provincialization
that.
orders were stayed in the order. Since that is dismissed, Milord,
They were permitted to approach the tribunal, isn't it?
yes, they were asked to approach the tribunal.
Any order passed by the tribunal?
No, Milord, not to our knowledge.
This is the issue. I think you better withdraw this and file a writ petition. That is much better. How can you issue a notice?
Because in that case, provincialization
The
was stayed.
writ petition was dismissed. Your provincialization was stayed. Writ
No,
petition was
We
dismissed.
were respondents there, Milord.
That's why I'm saying your provincialization was stayed.
Was stayed during the petition,
After that, writ petition was dismissed.
dismissed.
And
Stay orders were vacated by the court,
was
by an earlier order, without it was vacated.
so they approached the division bench
Right.
by appeal. When the appeal was heard, they were permitted to approach the tribunal.
Yes, appeal was withdrawn for that.
Yes. Then how can we issue a notice in this contempt? You file a writ petition directly for mandamus to release your salary.
My,
Mr. T.B. Chalia, learned senior counsel, assisted by
UP Chalia.
U.P. Chalia, learned counsel for the petitioner. Place for withdrawal of this contempt petition with liberty to file an appropriate application. Contempt petition is accordingly dismissed with liberty as
we withdraw, on withdrawal. My,
liberty as well.
See. May please, Your Lordship. Lordship, last occasion direction was given to produce a copy of this Honorable High Court. But
What is this matter about?
Lordship, matter is pertaining to seeking on advanced increment, Lordship, having valid B.Ed degree, Lordship.
Where is this communication of 21/7/2016?
Lordship, Annexure 7, page number 39, Lordship.
Yes, Bora.
He was also elected a similar order in page number 50. That order can be similar issue. Not similar, furnish just now a copy of the
Page number
15, and operative part is 51. We will file a press representation there, then the director will examine.
who will examine?
It will, ultimately it is the director petition. The director education petition. This was phone number 3. Yes, that's phone number 3.
Is it not the inspector of schools?
Inspector, he will give a presentation inspector, it will forward it to the director. Ultimately, director has to act.
What, Mr.
J. Hatimuria.
J. Hatimuria, Learned Counsel. Also heard. Mr.
I am for respondent number 1 and
Sharma, Learned Counsel, Standing Counsel, Secretary Education. For the respond number 1 and 2.
Yes, ma'am.
I would say as Bora, Learned Standing Counsel, BTC, for the respondents, 3 and 4. Stop. There are several as assistant teacher.
yes, Lordship.
The case of the petitioner is that he is presently serving as assistant teacher within bracket arts at Rauta Station High School. And he acquired the B.Ed degree from Due Mornoi B.Ed College, Due Mornoi under Guwahati University. Which year? In the year 2005. Correct?
Yes, Lordship.
Stop. And accordingly, he is entitled to one agreement, one advance increment, which however has not been, which however has been denied to the petition. Stop. But Learned Counsel for the petitioner submits that coordinate benches of this court have also passed orders directing for necessary verification in this regard and for passing appropriate orders, comma, if upon verification it has been found that the B.Ed, that the petitioner has the B.Ed degree in question. Stop. Learned Counsel refers to the order dated 27/6/2023 passed by this court in WBC 3724 of 2022. Correct?
Correct.
Stop. For learned counsel for the petitioner has also drawn the attention of this court to the communication dated 21st July 2016, written by the Joint Director of Secondary Education, Assam, and addressed to the Inspector of Schools. Within bracket all 811. KTC, Pan Bazar, wherein it is stated that all assistant teachers are eligible to get one advance increment for acquiring B.Ed degree, provided he/she has joined before 3/7/2012 and obtained B.Ed degree from UGC recognized university and NCT approved B.Ed college. Stop. When did you join?
Lordship, on 1/3/2011. 1/3/2011.
It is submitted that the petitioner was initially appointed as assistant teacher in English on contractual basis by the school managing committee on 1/3/2011 by the school managing committee of Rauda Station High School, correct?
Yes, Lordship.
On 1/3/2011. Stop. Para. Considering the above, comma, this court is of the considered opinion, is of the opinion that if the petitioner has acquired B.Ed degree from a UGC recognized university with NCT approved B.Ed colleges and joined the institution before 3/7/2012, then the petitioner would be entitled to one advance increment. Stop. However, comma, the entitlement of one advance increment would be subject to a verification to be carried out in the level of
Director of Education PTC.
in the level of the director
Director of Education PTC.
of Education BTC Kokrajhar.
Okay.
Stop. Accordingly, comma, para. This writ petition is disposed of, directing the petitioner to submit a fresh representation to the respondent number 4,
Inspector of School.
public the Inspector of Schools, Udalguri District Circle, comma, Udalguri, along with a certified copy of this court's order. And thereafter, within a period of
3 weeks, Lordship.
within a period of 3 weeks from today. Stop. Thereafter, comma, the Inspector of Schools, Udalguri District Circle, comma, Udalguri, shall forward the said representation to the respondent number 3, oblique the Director of Education BTC Kokrajhar, forthwith. Stop. Consequently, the respondent number 4 shall make necessary verification. I think the
So number 3. Response number 3, the director. Ultimately, director has to take a call, man.
Director will have to do the very, will it not be the inspector who will do?
All the papers, inspector will do the needful and send it to forward it with all the papers.
Then you can say within a period of 3 weeks from today. Draft a comma. The respondent number 4 shall make all necessary verification as to whether the petitioner has obtained the B.Ed degree from the UGC recognized university and NCT approved B.Ed college, and the petitioner have joined before 3/7/2012. And after such verification, if it is found that the petitioner has the required qualification, as mentioned in the communication dated 21/7/2016, the all necessary documents shall be forwarded forthwith to the respondent number 3, the Director of Education BTC Kokrajhar, who in turn shall take appropriate steps for granting one advance increment to the petitioner within a period of
4 weeks.
4 weeks from the date of submission.
On the date of receipt of the forwarding letter from the
Date of receipt of the forwarding letter
from the
from the response number 4. Stop. With the above observations and directives, the petition will be disposed.
7.
Method pertains to non-payment of family pension, my lord. The petitioner is the dependent unmarried daughter, my lord. Kindly see page 30, my lord. The direct page 30, my lord. Director of pension refused to pay the pension, my lord, stating that, my lord, basic pension, my lord, rupees 0. Page
Where is
30,
it?
page 30, my lord, annexation 9, my lord. Sir, I am to forward herewith to PPO so of Tondrali Roy, daughter of late, and 0 per share from family pension with effect from 0. And thereafter, my lord, the inspector of schools again, my lord, forwarded the, my lord, proposal. Kindly see page 33, my lord. Page 33. To the director of pension, my lord. But till that, my lord, no steps has been taken by the director of pension, my lord.
Yes, David.
On the
Lordship, that page 33, your lordship, downward portion, your lordship. The cross mark on the endorsement of this directorate, that means the directorate of pension. So it indicates that the same has not been received, your lordship. It is a non-marriage and non-employment certificate, which is required. So along with the proposal, if it comes, I talk with them. If the proposal is received, accordingly, they will do the needful as part of prevalent rules and regulations. So, because that very letter which the petitioner is relying, that page 33, downward, your lordship, that is cross mark.
It is an official letter, my lord.
Maybe.
It is made the inspector of school made.
No, are you sure this is cross?
Yes, your lordship. Even
No, my lord, it is the initial, my lord.
that means this communication that has been prepared by them.
Now, if it is cross, how did the seal come? From where did the seal come?
My lord.
That they will know it, your lordship.
How they will know it? The official seal is there.
This is after receiving the
To
seal,
me,
my lord.
the statement that has been paid, the cross mark on the endorsement of this directorate on the letter dated AMO clearly indicates that a letter dated such was not accepted in this directorate. So along with this non-marriage and non-employment certificate, if the proposal is sent to the authority, your lordship, so they will do the needful, your lordship.
Then, my lord, the inspector of schools may
Who appears
clarify,
to
my
be
lord.
Inspector of schools.
Clarify, my lord. Inspector of schools. Whether this letter issued or not, my lord.
Was it issued?
33.
See, I need to get the instruction letter.
But Mr. K. Patil and the counsel for the petition. Stop, Mr. B. Dury. Then the governor advocate. appearing on behalf of the respondent number.
I'm for respondent number 4, Your Lordship. 4
Director.
and 2. 2 and 4.
For the respondent number 4,
2 and 4.
Public Director of Pension Assam submits that the office of the Director of Pensions Assam has not received the letter dated 27/2/2023 written by the Inspector of Schools, Chirang District Circle. What is this? Kachalgaon. Kachalgaon.
District Srirang Malak.
Okay, Chirang District Circle. Oh, stop. Bora, Mrs. Bora, the understanding council. You are for BTC.
BTC, or respond now 5, 6, and 7.
The understanding council BTC. Prays for some time to enable him to receive instructions
Regarding
as to whether the communication dated 27/7/2023, correct?
Not.
Within bracket annexure 12 to the writ petition has been issued by the Inspector of Schools, Chirang District.
More so, Your Lordship, that non-marriage and non-employment.
That we'll see.
That
once
also-
he gets-
that also.
When do you want?
It will be after 10 days.
Release the matter after 2 weeks.
Date may be fixed, 10/6.
It will come.
May I please, Your Lord?
Hmm.
The petitioner before your lordship, he was selected for the post of assistant professor in the college. Then his selection was challenged before this honorable court. Then honorable court remanded the matter to the secretary BTC for reconsideration. Then this impugn order has been passed at page 40.
Where's the order passed by?
Page
this court?
40, madam, annexure 10.
No, where's the order passed by this court?
My lord, that is page 35. Because I was the PhD holder, I was given the preference. That is why, my lord, this my selection was challenged. Then this honorable court said no, PhD may not be given a preference, so it was sent back to the secretary. And it reflects in the impugn order also.
Where's the advertisement?
Well, advertisement at page 26. Page 2.
Yes.
I was having the PhD degree. That is not the issue. And now page 40, annexure 10. One another person's respondent number 6 has been selected, showing that she secured 62.14 marks in the interview.
Yes.
Smile. Then your lordship kindly see the selections committee's marks offered, that is page 30. It starts page
Page?
30, C0, Annex 7. Consolidated statement of presentation and interactions. The marks has been given by the selection committee is. And
What's your name?
my name is last, that is page 32 last, Madhav Sutradhar. I secured 55 and I was selected at earlier point of time. 55,
Yes.
last. Now, it is correct, 55 I secured. Now, response number 7, your lordship kindly see page 31. Response number 7. It is shown that total is serial number my lord 14, 14. Korobi Das. Grand total, my lord, it is shown 435. And average shown 62.14. That reflects in the impugn order also. If your lordship calculate these marks, then it will be 382. But it has been shown 435. And average will be 54.57. Wrong arithmetic, my lord, wrong calculation. And accordingly, she has been selected.
How do you come like that? How do you come?
My lord, case 31, Korobi Das. If you grand total, it is shown 435. But if your lordships calculate it 53, 53, 53, 52, 54, 50. Huh? In paragraph, I have calculated it in paragraph 11 also. Paragraph 11, I have shown.
So his average will be
54.57. And I have secured 55.
382.
382.
Average should be divided by
7.
7.
And I am having the PhD degree also. I am from the PTC area also.
So his average is 54.
54. My is 55. But she has been selected and showing that she has secured 64.12. Wrong calculation. That's
I have gone through it, like, there is a wrong calculation. Like. And if losses turns to page number 30, select consolidated statement for election matter. The petitioner is not the number one. Petitioner number one is TL number 5. He got 67%. Everything had to be redone. He is the highest. There was three Kolita.
one Dhanasri Kalita.
No, Dhanasri, Dhanasri Kolita. 67%. He is the highest.
She secured 67, but she was not selected because she was outside of the BTC area. And
outside of
BTC area. That is why she was, though she was the writ petitioner in
Who is within the BTC area?
myself and response number 7.
Only 2 of
My
you.
lord. That is why it was considered. And I'm having the PhD degree also.
PhD degree is only for giving you the average of 50% marks.
That is, it may not be considered because earlier, whether my lord, this honorable court already held that it may have been given a preference. That is correct. Oh, maybe. But if in selection, that I have secured more marks than the private number 7. Even though.
The calculation is around yes, that's it, that's really clear, man. Whether preference will be given to the PTC, the advertisement reflects that a preference will be given to the PTC person, whether law provide that preference. And you have to do the calculation, you have to.
You get
do the
instructions and come back.
Lordship, that can be done.
My lord, sir, this order may be stayed because the appointment process.
Mr.
And hoc.
And Hawk Learned Counsel for the petition. Petitioner is aggrieved by the order dated 26th April 2024, issued by the Secretary, Botolan Territorial Council, whereby the issued by the order dated Botolan on the basis of the order dated 13/12 issued on the basis of the order dated 13/12/2023 passed by this court in WBC number 6333 of 2022, whereby the respondent number 7 whereby the respondent number 7 was selected for appointment as assistant professor in the Department of Assamese in Barama College, Barama. And a direction was issued to the Director of Education PTC to post steps for appointment of the respondent number 7 after following due procedures in this regard. Stop. It is the case of the petition that the consideration of the consolidated statement of presentation and interaction within bracket Annexure 7 to the present petition would indicate that the respondent number 7 is shown to have obtained a grand total of 435 marks and an average of 62.14.
62.14.
Stop. However, on the proper calculation of the marks given by the selection committee, the total grand total comes to only
382.
382 marks with an average of about 54%. Correct.
54.57.
54.57. Stop. However, in respect of the petitioner, he has got the grand total of 385 with the percentage of 55%. And accordingly, the petitioner should have been recommended for selection. Stop. For I'll issue notice. I think responder 7 has to issue notice. Petitioner, Mr.
I am for 1
K. Gogoi, Leonard Standing Council Higher Education appears for respondents 1
and 2, Lordship.
1 and 2. And Mr. Bora, Leonard Standing Council BTC appears for the respondents
3 and 4.
3 and 4. How about
5, 6, and 7.
petitioner to take steps for service of notice on the respondents 5, 6, and 7 by registered post AD within 1 week from Monday. List after 4 weeks. In the interim, the order dated 26 April 2024 issued by the Secretary, Portland Territorial Council, shall remain suspended till the next session.
Public.
May it please your lordship. The petitioner was an associate professor working in the Handy Girls College and he retired on 31/1/2021 and is aggrieved by the rejection order of his request of stepping up of pay with the junior. Now what happened, your lordship? The UGC has issued a notification granting three benefits of advance increments to all those teachers who during their service careers has acquired PhD. Now, this petitioner joined on 87, he acquired his PhD in 1991. There is no doubt about that. Now, many juniors who have joined after him in the college have acquired PhD at different points of time and they are given that benefit in persons to their notifications.
Later renew.
Yes, your lordship. Now, what has happened because of that benefit, that at one point of time, they march over me in terms of pay. And this happened in almost all the colleges. So now the government came up with a policy that will equalize the pay of all those senior teachers who are drawing less salary than their juniors because the law is well settled. A senior cannot draw a less salary than the juniors if other things are equal. And accordingly, the files were processed. My file was also processed by the college authorities. These are on record, I'll show you, your lordship. However, those persons who are similarly situated with me, some of those persons had been given the benefit of stepping up of pay. But this petitioner's case of stepping up of pay has been rejected by the DHE, that is the Deputy Director of Higher Education. And therefore, I am before your lordship.
Where's the order?
The order is at page 84. Has your lordship got it?
Yes.
With reference to the subject cited above, I am directed to state that that as per government OM such and such, it is inter alia stipulated that there are some discrepancies which have arisen among the teachers and librarians getting incentive from 1/1/1996 to 31/12/2005 and 1/1/2006 onwards. The senior teachers, librarians who are eligible to get incentives for acquiring PhD MPhil degree before 31/12/2005 are getting less pay than the junior teachers who are eligible to get incentive for PhD such and such. To compensate the discrepancy to pay, the government of Assam has decided to equalize the pay of the senior teachers librarian by stepping up the pay of the senior teacher librarian so as to make the equal pay to the juniors when the service conditions in all other respects are similar. In the instant case, the senior teacher concerned did not get any incentive for PhD and PhD degree is acquired not within the prescribed period of 1/1/96 to 31/12/2005, which is acquired on 12/1/1991. From the above, it is clear that the instant case does not fulfill the criteria prescribed by the government for equalization of pay. So the proposal for equalization of pay in respect of Dr. Hiranya Kumar Chaudhary, Associate Professor, Department of Chemistry, with such and such Associate Professor is hereby rejected. And now I'll say, your lordship, on the face of it, it's a wrong finding. There are two reasons for it. Equalization of pay by stepping up the pay is granted to the seniors when they're drawing less salary than their seniors if other things are equal. Secondly, if your lordships kindly come to page 91. This was the equalization of pay given to 7 persons. Now I'll draw your lordship's attention to serial number 3, Mr. Debattal Goswami. He did his PhD way back in 1993. And that is at page 97. Serial number 5. If your lordship see, page 97.
Yes.
If your lordships kindly say, the undermentioned candidates are declared to have qualified for the degree of Doctorate of Philosophy of the Guwahati University for those as noted against their names by the Executive Council resolution dated 15/2/1993. Serial number 5, Debattal Goswami. He was given equalization of pay. And the second one is at page 102. I'll read the second para. Peruse the government OM dated such and such, issued in connection with the allowing career advancement benefit to lecture such and such. Now your lordship will come to page, para 5, subpara 5, on perusal of the aforesaid documents. Has your lordship got it? It reveals that Dr. Sarveswar Das had and Dr. Anupama Borman Deka and some other lecturers were working in the Soigaon College from the date taking over the college under deficit system, that is with effect from 1/2/1985. It appears from the record that Sarveswar Das, lecturer in the Department of Economics, had obtained PhD degree on 16/11/1992 from Guwahati University, and Srimati Anupama Burman Deka, lecturer in Department of Assamese, has obtained PhD from Guwahati University in 14/6/1997. Now the finding, your lordship, at page 103. The penultimate paragraph. It is therefore decided to equalize the pay of Dr. Sarveswar Das at such and such with such and such, equalizing with Dr. Anupama Burman Deka. So these two examples are there whose pay has been equalized. And one more I'll give example, your lordship will kindly come to page 77.
Yes.
Now this person, he was similarly situated with me and in the same college. In pursuance of government notification dated such and such, Government of Higher Education Department has no objection in stepping up of pay of Dr. Dhirendra Mohan Kumar, Associate Professor, from the stage of 55,440 to the stage of 60,230 to equalize his pay with that of his junior Dr. Rosemary Borua Chaudhary, Associate Professor, such and such. So this Dhirendra Mohan Kumar, he was my colleague. We were working in the same college. He was given the benefit. Then the annexure I have just read now, 7 persons were given the benefit. They were from DK College, Mirza. So the concept of equalization of pay on which ground my was rejected is straightway hit by Article 14 and 16, because the Honorable Supreme Court has categorically stated that stepping up of pay will be applicable to all those persons who are senior to their, who are senior, not only seniors, but are drawing less pay than their juniors, provided other things are same. Of course, suppose now if somebody is given to do a tedious job, they may be given a special pay. Now, I cannot claim that my pay has to be equalized with that person. But in this case, when I am senior, I have all the qualification at par with my juniors. They cannot be allowed to draw much pay than me, your lordship. I'll just demonstrate one, how they have crossed the page 63, your lordship.
Yes.
This is a pay chart I have drawn. If a lordship says, I was drawing much more pay than them, 51,950. And they are drawing somewhere around 50,750, 49,240. Now, your lordship will kindly look at July 2009. And the second para is Bandana Navis and Dr. Mitali Goswami. They were given the advance benefit of advance increment from that day. So they crossed me on that day. And Rosemary Chaudhary crossed me on July 2011. She was drawing 60,430, whereas I was drawing 50.
Yes, we can issue notice. But Mr.
Arsina.
Arsina Learned Counsel for the petition.
Your lordship, I'm praying for the stay of that impugn order.
That is not required. What difference will it make? Issue notice.
Otherwise, if that is not stayed, your lordship, that cannot be examined, your lordship. At least that has to be stayed, because out.
Mr. K. Gogol.
For 1 to 4 lordship.
Higher education appears for respondents. 1, 2,
4 lordship, 4.
3, 1, 2, 3, and 4.
Lordship.
A. Chalia, then the Standing Council Finance Department appears for respondents. 5.
Respondent number 6.
MS.
K. Barpujari on behalf of A. Somwa.
K. Babujari, Learned Counsel appearing on behalf of Mr.
A. Chomwa.
A. Chamwal, Learned Standing Council UGC for respondent number 6. Petitioner to take steps for service of notice of respondents. 7 to 12.
No, 7 and 8. Your lordship, 9 to 12, they're pro forma respondents. If they contest, in that case, they can be arrayed as a main respondents. That's on application.
16 for service of notice on respondent number 7 and 8. And pro forma respondent also issue notice. Pro forma respondents 9 to 12 by registered post ED within 1 week. Respondents are allowed to file their affidavits. Plus list of performance.
Deeply obliged, Your Lordship.
10.
Very procedural. But the facts of the case are quite exhaustive, Lordship. I will try to, Lordship, submit briefly. I draw your Lordship kind attention to page number 48, Lordship. This is the 5th round of litigation, Lordship. Since 2013, the petitioner pursuing Lordship for his claim. Page 48, this is the order by which the school in question is provincialized. I have given the typed copy, page 48. Lordship, kindly come to the table, which is at bottom. While the school was provincialized, the service of the teaching staff, one post is kept vacant. Lordship says serial number 4, vacant. Then designation assistant teacher arch, date of and court case.
Where is that? Where is that?
Bottom, Lordship, page 48, from serial number 1, 2, 3, just below the Rupali Bora, vacant. That post is kept vacant, although 3 number of posts for assistant teacher has been sanctioned by the government, but this one of the posts for assistant teacher is kept vacant because of court case. So thereafter, Lordship, the petitioner, Lordship, approached this honorable court, claiming for provincialization. Ultimately, this honorable court disposed of the petition with a direction, Lordship, that Lordship will find at page 50, annexure I. Since this is a dispute regarding the claim for provincialization, Lordship, from bottom 2nd paragraph, since there is a district scrutiny committee and also the committee constituted by notification that the 30th January 2013, the matter will have to be resolved by the said committees, taking note of all the attending facts and circumstances and in accordance with law, Lordship. Now, thereafter, Lordship, the member secretary of the district scrutiny committee, they have scrutinized after spot verification, and ultimately the member secretary submitted its report by which recommending the service of the petitioner. That Lordship will find at page 53, annexure L. There are 2 reports, Lordship. The first one is 20th of November 2014, annexure L, page 53. So I am reading the last paragraph, Lordship. Hence, the particulars bearing the name of Sri Sunil Kakoti, that is the petitioner, is the staff list scrutinized by the district level scrutiny committee and forwarded for provincialization in the genuine particulars, and Sri Sunil Kakoti is the working teacher in the school. Hence, his provincialization of post of 3rd position is true and correct. Lordship, all along my claim is for the 3rd post, which is granted by the government for provincialization as an assistant teacher. Similarly, annexure M also, 5th of December, again the member secretary after verification submitted its report saying the same thing, that the petitioner is eligible. But what happened, Lordship, in the meantime, without considering this report of the member secretary in terms of the earlier court order, the director has issued the interim order, 7th of January 2015, by which the service, page 56, page 56. This order has been issued saying that relying on the report of the district scrutiny of 7th of August 2014, saying that the petition, the respondent number 7 is senior than the petitioner. So ultimately, the service of the respondent number 7 is provincialized, by order dated 7th of January 2015 without considering the earlier reports submitted by the member secretary of the district scrutiny committee. Now, agreed by this order, Lordship, 7th of January 2015. Now, what happened, Lordship? On the same day, that annexures P page 15, this is the minutes of the district scrutiny committee. Lordship, kindly come to page 60, annexure P. On 7th of January 2015, the director provincialized the service of the response number 7, and on the very same day, the district scrutiny committee, based on the earlier report, they have verified the documents of the petitioner as well as the response number 7. And by this meeting dated 7th of January 2015, the recommendation made by the district scrutiny committee in respect of the response number 7 by 7th of August 2014 that has been cancelled. Let's kindly come to the last paragraph. May I read the second paragraph? Page 60, annexure P. The Golaghat District Level Scrutiny Committee like to submit the following clarification regarding the third post of assistant teacher of Mamornoi Pancharatna High School, Novhanga, Golaghat. The scrutiny committee has re-verified the all documents and testimonials of Sri Sunil Kakoti, that is the petitioner, and Miss Deepika Barukiel, response number 7, along with on the spot verification report dated 4th December 2014, as already I have mentioned, of the Inspector of Schools, Golaghat. And decides that there is no sense of the committee's decision, resolution dated 15th of November 2012, which has been initially submitted to the DAC Assam on 20th November 2012, and the committee earlier decision resolution dated 7/8/2014 is treated as cancelled. Now, thereafter, the petitioner again assailed the order of 7th of January 2015, by which the service of Restorable 7 is provincialized, that Lordship will find at page 61, annexure Q. Order dated 18th of November 2019. Ultimately, discussing all the reports, matter has been remanded to the director to review the impugned order by considering the reports of the District Scrutiny Committee of 2014, as well as the District Scrutiny Committee's recommendation of 7th of January 2015. Also, kindly to page 64, paragraph 6. Accordingly, the present petition is disposed of, directing the respondent authorities, more particularly the Director of Secondary Education, to review the impugned order dated 7th of January 2015. If the director finds that the District Scrutiny Committee in their meeting held of January 2015 had indeed taken the resolution as quoted above, the impugned order dated 7/1/2015 also requires to be reviewed and consider provincialization of the petition. The director will do the needful as provided under section 24 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. And within a time period, direction has been given. Now, what happened, Lordship? Without reviewing the matter and considering the report of the member secretary and the resolution adopted by the District Scrutiny Committee on 7th of January 2015, the director has issued the impugned order on 20th of June 2023. The Lordship will find at page 65. Type copy, Lordship, and annexure R. In narrating all the facts, Lordship, and here, Lordship, he come with a new finding, as if, Lordship, I'm claiming as a for the post as a additional teacher. If you, Lordship, come to page 66. Page 66 from bottom, third paragraph. As per provision, direction was given that in view of the considering the report of the committee, you review the order of 7th of January 2015. But that was not done. But instead of he's saying that as per the Act of 2017 as amended 2018 under section 317, so there shall be additional post in the same subject in Vansar High School, High Madrasa, if the minimum students appearing in the list final examination, the highest class for the said subject exceeds 80 in each class for the second post and exceeds 150 in each class for the third post. Now here this 3111 is meant for only for the post of additional post. But here it is a case of the petitioner is that he is not claiming for the post of additional post. It is the third post which was sanctioned by the government prior to the provincialization of the school, and that post was kept vacant. But instead the ignoring those facts, Lordship, the director come with a new finding as if Lordship I'm claiming for the post as an additional teacher. But that is not the case of the petitioner. So ultimately, this order was also assailed, Lordship. That the petitioner Lordship will find order at page 69 and excerpt 5. Yes, Lordship, page 69. Your Lordship's order, and ultimately, you Lordship has set aside that Lordship will find at page 71 from bottom Lordship third paragraph, considering the all reports, may I read the fourth paragraph on a consideration, page 71. Thereafter, your Lordship set aside the provincialization order. On a consideration of the order dated 20th of June 2023, just now I have referred the impugn order passed by the director. The first ground that the case of the petitioner could not be considered on humanitarian ground. So I am not claiming the post on humanitarian ground. The District Scrutiny Committee on my eligibility and feasibility report, they have recommended my service, not on humanitarian ground. This is his own finding, humanitarian ground. Is not projected. You Lordship held that it is not projected in the direction passed by this court in the order dated 18th of 11/2019, that order of page 61 in WBC 79/2018. Further, the minutes of the district committee held on 7th of January 15 in respect of the petitioner would indicate that the scrutiny committee, after verification of documents and testimonials of the petitioner as well as the respondent number 7, along with spot verification report dated 20th/11/2014 of the inspector of schools, that is the member secretary of the district scrutiny committee, there was no change with regard to the recommendation of the case of the petitioner as on 15/11/2012 and the earlier scrutiny committee decision dated 7th of August 2014 was cancelled. So after considering all these aspects, your Lordship come to a finding. In that view of the matter, it appears that the director of secondary education Assam had reviewed the very order dated 7/1/2015 on wrong premises. So ultimately, accordingly, the same is set aside and quashed. Then direction is given. Accordingly, the matter is remanded back to the director or respondent number 2 to reconsider the matter afresh with regard to provincialization of service of the petitioner by giving an opportunity of hearing of the petitioner as well as the respondent number 7, and thereafter passed an appropriate order in terms of the order dated 18th of November 2019, passed in WBC 790 of so with 2 months from the date of receipt of the certificate copy of this order. So ultimately, Lordship, we have been heard, but ultimately, the impugn order, which is now assailed in this writ petition, again, Lordship, by reiterating the earlier facts, the director has issued the impugn order, which is now put to challenge in this writ petition. That Lordship will find at page 80, annexer, annexer V. Same Lordship, 23rd of January 2020, reiterated the facts and ultimately saying that since there is less number of students, I am not eligible for the third additional post. So ultimately, my prayer is rejected. Now, facts remain that the direction of the court that you should review the order in terms of section 24, that is not done. And the report of the District Scrutiny Committee of 2014 and the minutes of the District Scrutiny Committee, whereby the recommendation of the respondent number 7 has been cancelled. All those aspects has not been considered here at all, and reiterated the facts and ultimately rejecting the prayer of the writ petitioner lordship. So that is why I am again before your lordship. But what happened, lordship, in the meantime, this respondent number 7, he retired, lordship. He retired on service on 30th of March 2000.
30 July.
30th of July 2023. 31st of July 2023. But prior to that, lordship, this order was issued, but the director has not considered the report, the court's honorable court's direction, and at the same time, under section 24, it is not reviewed. Lord. So ultimately, I am suffering. Lord.
In this matter, my lord, notice may be issued here, my lord.
Director went on the same.
Same.
There is no provision
It to lordship, it is a replica of
on
that.
humanitarian grounds
Yes.
again.
My lord, 2011 and already.
What is wrong with you, director?
Replica of that June order, lordship, of 2023.
What is wrong with you, director?
And my lord, moreover, enrollment of the students also not passed to.
This is a different issue. This is a different issue now.
It is his own finding,
Only the
lordship.
direction is issued by this court. Number one, petitioner is not claiming provincialization on humanitarian grounds.
Yes.
Petitioner is not claiming provincialization on additional
Post.
posts. He's claiming provincialization on the basis of the third post.
And that post is kept vacant, lordship.
That was kept vacant.
My lord, there the provincialization was occurred on 2011 under 2011 Act. Now 2011 Act is struck down, my lord.
That has been struck down. That is
Yes.
not, that everybody knows that it has been struck down. But any acts taken prior to the striking down of the 2011 Act would stand valid. That
Yes.
also, that observation also was made by the
Yes,
court.
yes, that protection is given under section 24.
So my lord, notice may be issued in the meantime.
But they call them a counsel for the petition.
Only see my limited period that he is continuing, his service may not be disturbed. Lord.
Issue notice. Mr. U. Sharma, the standing counsel,
Secondary education.
Secretary Education appraised for respondents, 1, 2,
Hello?
One, 2, and 6, my lord.
1, 2, and 6.
6.
Scrutiny committee,
And 3, my lord, 3.
1,
Is there.
1, 2, 3, and 6.
3 and 5 by us.
3,
Three and
my lord.
3 and
Yeah.
5 by me.
You are
Then my
three
lord,
and
I am 1,
three and-
2, and 6.
1, 2, and 6. D. Daryl and Governor Advocate appraised for respondents, 3 and 5.
Deputy Committee.
7 is retired.
Lordship, at this stage, notice may not be issued, Lordship, against the 7, Lordship. I will take steps on respondent number 4, Lordship.
Petitioner to take steps for service of notice on respondent number 4 by registered proceeding with 7.
7 to number.
Stop. It is submitted at the bar that the respondent number 7 has retired on 30/7/2023. Stop. Accordingly, the notice on respondent number 7 is returned for the time. Stop. Respondents are not.
Extra copies.
List
Yes, yes.
list up to 4 weeks. In the interim, comma, it is directed that the service of the petition shall not be disturbed till the next.
Lordship, one more observation, the pendency of this requisition may not be a bar to consider the case of the under 2007.
Pendency of this
That may also be ordered.
shall not be a bar for the respondents to consider the case
Under 2017 Act.
under the.
Because section 24 already direction is given.
Under the, what act was that?
That act, Lordship, will Lordship, consider Lordship,
Under the.
and Lordship. Sorry, Lordship. Page 71, so in second paragraph, Assam Education provincialization of services of teachers and reorganization of educational institutions, bracket close, Act 2017, as amended 2018. Page 71 in second paragraph it is quoted. Deep level.
11.
May it please, your lordship. My lord, I was promoted to the post of professor under career advancement scheme pursuant to the recommendation of DPC on 30/03/2022. Thereafter, my promotion order was issued on 5/4/2022. That lordship will find at page 38. This is the type copy and the original is at page 39. In a block minute table. This is my name, my lord. Dr. Satyajit Paul. And I was promoted with effect from 17/5/2018. And in terms of this or notification, my lord, my age of retirement enhanced to 60 to 65 years, my lord. Pursuant to that, my lord, an impugn order has been issued on 31/3/2022 by the principal, Jorhat Engineering College. That lordship will find at page 42. I was released from service, my lord, on the ground that I have attained the age of superannuation since I was working as associate professor. For professor, the retirement age is 65. I came before this honorable court by challenging this order. This honorable court, my lord, right ordered at 8/9/2022 at page 53. Operative portion is at page 54. In the interim, was pleased to direct the parties to maintain status quo. Page 54, my lord. As per the order passed by your lordship, till that I am continuing as insurance principal of Golaghat Engineering College, my lord. In this week petition, my lord, 5804 of
This
2020.
petition is not disposed.
It is still pending, my lord. 5804 of 2022, the respondent number 1 filed an affidavit, additional affidavit, wherein they have annexed a copy of the OM that lordship will find at page 66 on 19/5/2023. Last page, my lord, page 66.
Yes.
By way of the said OM, they have withdrawn the earlier OM on the base on which my promotion was recommended to the post of professor. And now they have taken a stand in the earlier petition that since the earlier OM has already been withdrawn, therefore I am not entitled for promotion to the post of professor. So now by way of this writ petition.
Let us read this.
Yes, my lord. My lord, before that, my lord, I have also annexed a copy of the affidavit that lordship will find at page 62 and their stand is at page 64. Paragraph 3, my lord. The deponent begs to state that consequent upon the withdrawal of OM dated 28/3/2022, the notification number so and so dated 5/4/2020, page 66, my lord, has also ceased to have any effect. This is my promotional notification. And as such, the case of the petitioner cannot be considered in respect of the said OM dated 28/3/2022. I was considered by the Departmental Promotion Committee, my lord. I am eligible for being considered for promotion to the post of professor under the career advancement scheme. Now, my lord, they have taken this stand that since the earlier OM has already been withdrawn, therefore my promotional notification 5/4/2022, by which I was promoted from 17/5/2018, that stands cancelled, my lord.
Was this OM 28, 3, 2022.
That lordship will find at page 36. This OM is regarding, my lord, AICT recommendations, my lord, adoption of AICT public notice regarding requirement, extension of date, completing short-term training program, orientation refresher course for promotion of faculty members of engineering colleges and polytechnics under career advancement scheme. At the time of my consideration for the post of professor, my lord, this OM was holding the field. They have withdrawn it by notification dated 19/5/2023. And now they're submitting before this honorable court that since this OM is no holder long holding the field, therefore my notification of promotion of 5/4/2022 stands cancelled. By way of this OM, they have taken away my vested right, my lord, accrued in my favor. There are no other ground, my lord. I am eligible for being considered for the post of promotion to the post of professor under the career advancement scheme. Accordingly, DPC recommended me. Now, my lord, they have taken this stand. And when the matter was sub judice before this honorable court. My humble submission, my lord, this OM 19/5/2023 shall be stayed, my lord, so far as my case is concerned, my lord, till the disposal of this writ petition.
Yes.
My lord, let notice be issued, my lord, and this matter will be taken.
And my lord, no order has been issued till date regarding cancellation of my notification. This is their submission, my lord.
My lord, that OM was withdrawn because at the time, my lord, finance concurrence was not there, my lord. And that reason has been given in our affidavit, my lord, in earlier case. My lord, in this case, let notice be issued and tag along with those matters, my lord. The issue is already there.
Certainly, my lord.
When is the order matter coming up?
This is not, now date is not fixed, my lord, but lordship may be pleased to tag these matters along with those two.
Mr.
RM Dekar.
Article and constable. Issue notice. Mr. S. Das.
Yes, my lord. I'll be appearing for
And standing counsel, secretary.
higher
Higher education,
Higher
my lord.
education. Appears for the respondents, 1, 2,
1, 2, 3,
1, 2, and 3.
1, 2, 3, and 5.
5 also,
Yes, my lord.
1, 2, 3, and 5. And MS,
Tinlung on behalf of RK Talukdar, respondent
unit counsel, appearing on behalf of Mr. RT,
RK Talukdar.
RK Talukdar, and standing counsel, accountant general. Appears for respondent. Notice and respondents are complete, however, extra copies.
My lord, I.
Respondents are permitted to file counter. List up to 4 weeks.
Well, kindly short date may kindly be fixed because, my lord, since 1/4/2022, I am serving without any salary, my lord.
List the matter after 2 weeks.
And the date may kindly be fixed.
3 weeks, my lord. In the meantime,
Date may kindly be fixed, my lord. 3 weeks, date may kindly be fixed, my lord.
List the matter again out. After 3 weeks, you want.
3 weeks, my lord.
2 weeks.
In the meantime, I will file it.
On 26th
My lord.
June. Along with WBC number
5804 of 2022.
5804 of.
Well, since, my lord, they have not issued any order cancelling the notification, till then, my lord, the effect of this,
Consider the interim on the next.
my lord,
Pray for interim shall be considered for the next.
I am deeply obliged, lordship. You can update that for. Huh? No. No, already like years.
We have received instructions, but in this case, we are directed to obtain instruction. Lordship direct us to file an affidavit, we will file, bring on record, these instructions. Because petitioner has no permission.
Petitioner
has no permission to open class first year higher secondary class. This is our instruction.
Publication of notification.
Then let them file their affidavit.
Yes, we will file on record.
They've
As well as
received-
time being noted.
They've received instructions, let them file their affidavit. There's no point of passing over. for the
There
time.
is some urgency, lordship. The session will
Urgency
reopen
permission is
the-
not there, what is that?
No, Lordship, we have the permission duly, we have obtained duly permission, Lordship. In the, kindly see the page, Lordship. 60.
Council.
65, Lordship. That is the report of the IS, Lordship, submitted before the Director of Secondary Education, Lordship.
Hmm.
There is clearly mentioned the school has timely got permission, Lordship.
Where?
And in second paragraph, in middle portion, Lordship, that the then managing committee also maintained all the GOP procedure in appointment of the teaching and non-teaching staff. The said higher secondary school got feasibility report from Assam Higher Secondary Education Council with the subject English, Assamese, suggestions, logic and education, find memo number iman, dated iman. The Kasari Mahal High School also afforded permission for upgradation into the higher secondary school, find GOP letter number is suggestions, 7 June 2005. Lordship.
It is a report
Lordship.
from the inspector of school student digestion for upgradation only. There is no permission.
Where is that? Where is that?
Malo, can you see the the Assam Higher Secondary Education Council as those non-permitted institutions who is already acquired prior permission from the DSC to submit application for permission with relevant documents in the office of the council for verification and for enabling them to logging into Dorpon admission portal. Number 3, this pertain to mention here in that only those institutions are eligible for applying for academic permission in the office of the Higher Secondary Council, which have already acquired prior permission, final registration from the office of the Director of Secondary Education, Assam, for opening class 2 stage. The Assam Higher Secondary Education Council had issued notice twice on 14 June 22 and 3rd of January 2nd May 2023 for compliance of the procedures required to be followed for admission to students into higher secondary first year class for the session 2024-25 in the Dorpon admission portal in case of non-permitted institution. They are non-permitted school, that's why they were given notice twice. You apply for, you get the permission, but they have failed you to it, and now they are coming for Dorpon portal to open for them. That is not permissible.
Let them file the affidavit.
Please, we file affidavit, my lord.
But
Details.
Mr. DC not, then the counsel for the petitioner.
Page 52, Lordship, we have also annexed here to the permission popularity. Page 52.
I have not seen any.
Mr. DC Judea Leonard, additional senior government advocate.
Well, I was a standing counsel as a.
Then standing counsel.
Yes, sir. Response number 3.
AHSCC, correct?
Yes, 3, 4,
Then
and 3 and 4.
AHSCC, submit.
So we have 1 and 2.
That the matter that he has received instruction. And please, for how much time?
2 weeks time.
2 weeks time to file complaint. Where is allowed? Yes, after 2 weeks.
They will provide me extra copy, my lord.
Okay, 2 weeks, give a date. This down.
19 June.
June.
They will provide me extra copy.
You provide extra copy.
Obliged.
13 of Delhi list, no step.
May pleasure. My lord, in this case, I have taken steps, but notice could not be served because there is a typographical mistake, my lord.
Where?
At page 3, my lord, in cause title, page 3 of my petition.
Yes.
A serial number, in giving serial number, there is a mistake, my lord. 1, 2, at page 3, my lord.
You'll have to file an IA for correction of the serial number.
Lord, if your lordship permit me, then
There's already a notification. Do you know that?
No.
That you cannot do it by hand anymore.
Yes.
You'll have to file an IA.
Yes, I may be allowed to file an IM.
Mr. Doctor
P.K. Goswami.
B.K. Goswami, Learned Counsel for the petitioner, submits that he could not take steps on the respondents as directed by this court on 10/2/2022, inasmuch as there's some discrepancy with regard to the serial numbers of the petitioner, of the respondents. He therefore submits that he may be allowed to file an appropriate application for correction of the serial numbers of the respondents. Praise allowed. List after
2 weeks, my lord.
you want 2 weeks.
And I have to contact my client, my lord.
List after 2 weeks.
Must.
10, implement of party. 15,
None appears for the applicants. List after 2 weeks.
16,
But in this case, I have filed one IA to implement Director of Boroland Territorial Council, my lord. By mistake, it was not inserted at the time of filing the writ petition. Lordship, kindly peruse the para 2. Director to entitlement. So I may be allowed to implement the present director.
Third time is, any objection, Naya? Third time is K. Devil and the counsel for the petition, for the applicant. By this
Second
application,
thing,
no, also heard Mr. P. Nayak, then standing counsel, BDC. For all the respondents,
Yes, my lord. All the respondents, repetition of application.
no, not the headmaster, I think.
Headmaster, no.
No, headmaster by this.
For the opposite parties, 1, 2, 3, and 5. Stop. By this application, the applicant is praying for implement of the Director of Education, Butulen
Territorial Council, Kokrasa.
Butulen Territorial Council, Kokrachar, Assam. As party respondent number
5.
5 in WBC number 5255 oblique 2020. Stop. It is the case of the applicant that the proposed respondent for implement was not made in the main writ petition due to inadvertence. Stop. After considering the condition in the present application, the prayer for implement is allowed as disposed in the main writ petition in view of the order passed to the Naya number so and so. Let the director so and so be implemented as party respondent number 5 in the present writ petition. You take notice, Mr. P. Nayak, understanding counsel BTC, accept notice on behalf of the newly implemented respondent number 5. As such, no formal steps are required. Stop. However, petition is directed to file an amended course title within 1 week from today. Stop. You want to file affidavit? Not yet. Mr. P. Nayak, London Standing Council PDC, prays for how much time?
What may done with 4 weeks now.
Prays for 4 weeks time. Prays for 4 weeks time to file affidavit. Prays allowed.
17, admission.
With legal lawsuits. This case relates to non-payment, non-regulation of the services of the petitioner, my lord. In this case, my lord, petitioner is a drop gate 4, this case, and next case is LDA, lawsuit already been heard, 18, my lord. What happened in this case, my lord? Petitioner was appointed before the provincialization of the school, that is pays lordships. 15,990. Annexure 18. As per the decision of the managing committee of Janata High School, Moshin Ali is appointed as a gate 4 in the Janata High School. Then he joined lawsuits, next page 19. He joined on 2/10/1990. Then his service has been approved. That is page 21. And his name shown as a Moshin Ali gate 4. That is last name.
Shell 13.
Yes, my lord. 21. Page 21, my lord. 6 December 1994, his appointment has been approved by the, provisionally approved by the Inspector Schools, my lord, NDC. Page 21. His name is shown as a last. Then lordship, then his name is also showing the teaching and not teaching staff. Moshin Ali, serial number 13. In the meantime, school was provincialized in the year 1996, my lord. And he was dropped, my lord. Then what happened, my lord? Then this honorable court has passed an order, that is, lordship knows, first day of September 2003, this honorable court passed an order to provincialize the services of the drop, who has already been dropped.
Where's that order?
Then that is page, it starts at from 29, page 29.
Yes.
And may I read, my lord judgment?
No, I've read this.
Yes, your lordship's. Jipon Then what happened in 2005, my lord, an advertisement was made. Since after obtaining the order, government has not done anything, my lord. Then an advertisement was made, my lord, for in the school of high school, LP, ME. Then we approached this honorable court again. That is, then another order has been passed. That is, it was page 34. Then this honorable court passed an order to make an hyper committee, my lord. And accordingly, hyper committee was made, my lord.
Where is that?
And the order is lordship kindly peruse page 48, annexure H. It shows that some of the on inquiry that lordship's page 48 kindly peruse. There is an order passed by the commissioner and secretary. It has come to notice of Education Department. May I read, my lord? That after publication, the name of the drop teacher in newspaper, some teachers whose name did not appear in the list of published have submitted petition to the department showing various reasons. Some of the petitioner have enclosed copies of the High Court too. It appears on inquiry that some of the matters were not placed before the hyper committee in their meetings held from time to time, that is before submission of the report. This has resulted in new court cases as part of the direction of the Honorable Court direction. And the left out cases are to be examined and placed before the High Power Committee. To comply with the direction of the Honorable High Court, government has decided to hold a meeting of the High Power Committee to examine the above mentioned case. That is the teacher who applied for the screening committee in the response to advertisement dated 15 December 2005, but whose cases left out unattended and not placed before the High Power Committee. Therefore, it is directed to that officer, assistant legal cell, assistant branch will check their records and ensure it submit left out cases 31st October 2008, my lord. Then then your lordship kindly turn page 49. One notification was issued, my lord, by the commissioner and secretary, where the leftover cases have been enquired and reconstitute the high power committee, my lord. The commissioner and secretary is there, the commissioner and secretary to the government education there, T.R. Hazarika is there. Then lordship, what happened? The motionally approached before this honorable motionally approached before this honorable court that annexer J, page 50. And 11 portion is that the last part of the page 53. The petitioners in this writ petition have claimed for provincialization of their services, containing entirely that though they have been complete 2 years of their services prior to the date of provincialization of teaching and non-teaching staff of the respective schools. Their cases for provincialization have not been considered, though required to be considered in view of the judgment passed by the court and also decision of the government of Assam in that regard. Mr. Goswami, Learned Standing Council Education Department submits that having regards to the claim of the writ petitioner that they have completed 2 years of services prior to the date of provincialization of teaching and non-teaching staff of the respective schools, their cases would be placed before the High Power Committee for consideration, which shall verify the claim of this writ petition and pass necessary report. Ms. Devi, Learned Counsel for the petitioner, submits that the writ petition may be disposed of directing consideration the case of the petitioner by the High Power Committee based on the school's records and to pass necessary orders. Having regards to the aforesaid submission advance, the writ petition are disposed of directing the placement of the cases of the writ petition before the High Power Committee for consideration based on the school records and to pass necessary order for provincialization of their services, provided they have completed 2 years of service prior to the dates of the provincialization, the teaching and non-teaching staff of the respective school, as the government has accepted that the job teacher who were appointed 2 years prior to the date of provincialization would be provincialized. The said exercise are completed within a period of 3 months from today, my lord. Then what happened, my lord? The High Power Committee has passed an order, my lord, and rejected the claim of the petitioner, my lord. It is shown that the matter of that page 55, my lord, Annexer K. The matter of Mohsin Ali, Janata High School, Borinagar, Nalbari was placed before the committee as per government memo dated 29/2/96 and memo dated there is a provision of only one post of the Grade 4 in high school and one sanctioned post of Grade 4 was allotted to the school at the time of provincialization. That is not my case, my lord, actually. The petitioner in this case joined as a second Grade 4. Therefore, therefore, his name was not recommended by High Power Committee as a drop Grade 4 employee of the school. Actually, what happened in this case, my lord, all the drop were leftover drop teacher, my lord. At the time of provincialization, they were dropped, my lord. And drop are on the basis of drop, there is a government make a policy decision to regularize the service of the petitioner who were dropped, my lord. On basis of order passed by this honorable court 2003, my lord, 1st September 2003, my lord, this honorable court passed an order to regularize all the drop teachers, teaching and not teaching staff. But it is not correct that is why I approached this honorable court to set aside the order and regularize the service of the petitioner, my lord. Because all are second drop teacher. They are not third or fourth, my lord. They are second, and my lord, they were a second drop teacher before the provincialization of the school also. At the time of provincialization in the year 1996, my lord, they were left out, my lord. That is my case, my lord. This honorable court pass order, my lord. If your lordship kindly, your lordship can pass like this order also. I have shown that the second drop teacher, drop Grade 4, has already been regularized in the year 2012, 13, 14, like that. In another case also, my lord, that motion, Mr. Sharma was appeared, my lord. I have filed one affidavit showing that the second grade for were regularized, my lord. And that is LDA, of course. So both the cases are same order, my lord. His belongs to, second case is belongs to LDA and this one is grade 4. So lordship, my humble prayer before your lordship will kindly set aside the impugn order and pass necessary order to regularize the service of the petitioners. HYPA committee, they don't have knowledge that these petitioners belong to second holding the second grade 4.
Yes, Kaushik.
My lord. Your lordship disposes in terms of the order that is handed over, my lord. 1911, 2019 in WPC 2801, 2017.
No, here there was a,
But my learned senior is claiming that she is also a similarly situated person as like the person who has been regularized, Abdul Kudu. If that be so, my lord, the government will verify. Otherwise, my lord, if your lordship, the lordship takes up the appointment order of the petitioner at page 21 in the litigation.
Yeah,
There's no dispute, my lord, that he was the second grade 4, my lord. One
Approval order.
page 21 is the order of approval. Lordship will find Roman serial number 12, Nosad Ali, grade 4, class 10. He has been provincialized as there is only one post for the high secondary school for grade
At
4
that time, my
at
lord.
that point of time. And the otherwise also Jibon Deka and all, my lord, this all related to drop teachers. Though later on the government took a policy including the non-teaching staff also. And accordingly, the expert hyper committee has examined the cases. The direction was to examine by the hyper committee. Hyper committee has examined and has very rightly rejected it, page 55 minutes.
Can you give it like rejected? Since I mean, not rightly rejected, my lord. He admitted Jivon Deka, and now he stated that hyper committee has rightly rejected. It's a contradictory statement, my lord. I was not provincialized at the time of provincialization. After that, we approached this honorable court passed an order. Several order has been passed, my lord. Because of pick and choose manner, my lord, my service hasn't been regularized. Now the hyper committee stated that I'm at the time of provincialization, I am a second drop. Yes, I'm a second drop. It's admitted. And all the second drop teachers were approached before this honorable court at that time, and they make a policy decision to regularize the service of all the second grade 4 and grade 3 teacher and along with the teachers who are provincialized. And lots of I have submitted in another cases that there are lots of grade 4 and grade 3 were regularized at the time of after obtaining the order, my lord.
can we dispose of on this line?
My lord, in this line.
My lord, provide with a direction to set aside the impugn order, my lord. That order is not there. I want that order, your lordship kindly inserted. It should be set aside. Otherwise,
That
it
has
will
to be
remain as it is, my lord.
The petitioner has to make out a case faulting this order, my lord. There is no fault in the decision-making process, my lord.
Lordship kindly peruse the Annexure E also.
My lord will observe
23.
that the Hyper Committee has rejected the case. However, the petitioner has placed this order and is relying on this order saying that it is a similarly situated.
Mm.
When did the high power committee?
It is still exists, my lord.
39/2015.
Case
15,
55,
yes, my lord.
2015.
Okay, third time is K. Devil and counsel for the petition. Also heard Mr. V. Kaushik. Then it's standing counsel secretary education.
Secondary route.
All the respondents?
All the response.
Yes, my lord.
All the respondents. Oh. Para. It is the case of the petitioner that he was appointed as a grade 4 chokeda in the Janata High School. What is it? Gurni? Gurinagar.
Huh. Yes, my lord.
Gurinagar.
Janata High School,
Gurinagar, is it?
Borinagar.
On the basis of a decision of the managing committee of the said school. The petitioner joined to the said post on 2/10/1996. Stop. The inspector of schools, NDC, Nalbari, by an order dated 6 December 1994, gave provisionally approved the appointment of teaching and non-teaching staff of the said Janata High School, Gurinagar. And in the said order, the name of the petitioner appears as serial number 30. Stop. When were your school provisionalized?
Then teaching and non.
Where is the provincialization of?
Order I have not annexed, my lord. I have mentioned, my lord.
Where have you mentioned?
Mentioned, my lord. Provincialize, para 4. 22/3/1996.
These teaching and
Yes, ma'am.
non-teaching staffs of the Janata, what school was that?
Janata High School.
Janata High School, Gurinagar, was provincialized on 22/3/1996. However, the name of the petitioner was dropped. Stop.
No, that is okay.
Para. The case of the petitioner was placed before the high power committee. No, not select.
As per the direction of this.
As per the direction of this honorable court that lordship in WBC number 484 2012
Page,
page 50
page,
50 my lord. My case number is
2350.
2350 2013.
on the directions. Passed by this court. By order dated 23/6/2014. In WBC number 2350 of 2013. The case of the petitioner was placed before the High
High
Power
Power Committee.
Now, the High Power Committee in its meeting held on 39/2015,
20
correct, 39/2015,
39.
39 2015.
39/2015.
And dispose of the matter.
Could not recommend the case of the petitioner. Now, the relevant portion of could not recommend the case of the petitioner on the ground that there was no provision for appointment to grade 4 post. On the ground that there is a provision of only one post of grade 4 in a high school. And one sanctioned post of grade 4 was allotted to the school at the time of provincialization. And as the petitioner joined as second grade 4,
Yes.
his case could not be recovered.
Continue.
Stop. Para. The relevant portion of the resolution of the High Power Committee, which held its meeting on 39/2015, reads us under 8-way, page 55.
55.
Stop. Para. MSR Devi, K Devi, learned counsel for the petitioner, has produced a copy of an order dated 16/7/2013, by which one Muhammad Abdul Qudus
Yes.
was appointed in the grade 4 post in Langla Higher Secondary School, which clearly indicates that the appointment of a grade 4 post is possible in a higher secondary school of a higher secondary, in a higher secondary section of a higher secondary school. The order dated 16/7/2013 reads as under B to B. Is here.
High school.
Learned counsel for the petitioner. Supper.
No, he
Submits.
took high school. This will get it. No, that is it.
That the
No, it did that.
case of the petitioner is similarly situated with that of the
That's
said
because I think the
Muhammad
amalgamation.
Abdul Qudus.
Amalgamation is that.
Stop.
Not amalgamation is that.
what do you want to do? You want to reconsider the matter?
Malab, the last paragraph as it was directed by the.
Okay, then you say I will say that you are agreeing for reconsideration.
Malab.
Mr. P. Kaushik Para. Then Standing Council, Secretary Education Department submits that the respondents may be directed to reconsider the matter as to whether the case of the petitioner is similar with that of the said Muhammad Abdul Qudus. Correct?
Yes.
So, accordingly, this petition is disposed of, directing the respondent authorities to consider the claim of the petitioner. And if it is found that the petitioner is similarly situated as the aforesaid MD Abdul Qudus, similar treatment may be afforded by giving appointment to the grade 4 post in the said school, which exercise shall be undertaken and completed within a period of 3 months. 3 months from the date of receipt of a certified copy of the order.
Till then, he will do, become set aside, well, till then, the impugn order may kindly be set aside, otherwise it will be
Then
reversed.
my lord will have to come to an observation that this impugn order is wrong.
I'm just giving it by way of this thing only. Similarity.
Similar.
Similar, my lord. I have shown, my lord, I have filed an affidavit that all the remaining, the person who were provincialized, my lord, they were a second drop post, my lord. Your lordship kindly peruse the affidavit, my lord, affidavit filed by me, filed by the
Additional affidavit.
additional affidavit. I have shown that in the year 2012, all the candidates, my lord, they were teaching and not teaching staff. That is annexer 70 page 74, annexer B, my lord. They were I mean to say second gate 4 and gate 3, my lord. And I have annexed one appointment letter, annexer A, my lord. One Amiruddin, my lord, who is the second LDA, my lord, were appointed by the managing committee on 38/6/1994. His name is shown in this list, that is serial number 4. Same, almost same, my lord. The earlier was gate 4 and this one is gate 3. Similar order. Huh? Also kindly be passed.
Rejection to court.
Last of the set. Okay, লিখেছে
Amiruddin.
Amiruddin, his name is shown as a serial number 4 in the list, published, my lord, after examining the high power committee. They have already been regularized and they have been working, my lord.
Yes, Kaushik.
My lord can dispose it of as like the earlier one.
You should keep it in the file.
Instead of you don't want to give it this. Lordship, instead of Abdul Qudus, Lordship kindly shown the name I have annexed, my lord. Amiruddin name kindly be shown here.
Okay, give me your facts. Third MSK Devil and the counsel for the petition. As well as Mr. B. Kaushik. Then it's standing counsel.
Well, a similar order, only schools names and date of appointment
Secondary
will
education
be.
for all the respondents. Where's your appointment order?
Yes, my lord, that is ABC,
Page 18, madam.
page 18. 26, 1994. 28. And next page 18.
The petitioner was appointed as an office assistant
Yes, my lord, okay, LDA.
in Patubara Anchalik Madrasa High School.
Padupara.
On the basis of the managing committee's resolution. Was appointed as office assistant in Patubara Anchalik Madrasa High School
Useful pencil ketia sile. Nalikan ki.
by an appointment letter dated 26/1990,
96 it is.
issued by the headmaster of the said school. On the basis of a resolution passed by the managing committee of the said school.
Itu gimana sila hidup asun? Eke dinai husile.
The petitioner joined to the said course on 26/1992. Stop. The inspector of schools, ETC, Golpal,
228.
by order dated 19th November 1994. Provisionally approved the teaching and non-teaching staff provisionally approved the appointment of 4 incumbents of Patubara Anchalik Madrasa High School. Stop. The name of the petitioner appears as serial number 4 in the said order dated 19th November 1990. When was your school
But
provisional?
same date 22/03/1996. School was provincialized. Same date, man.
After that, you go over the same thing. Or, however, I said MSRDV, right? In the next part, that's where I said the petition order. Don't say petition order. Petition, the KDB Learning Council for the petitioner has drawn the attention of this court to the order dated 24th September 2012. No, before that, where is that?
Yes,
rejection by
my
the
lord, he
High Court
approached,
of-
no, he approached
I
before
covered
this honorable.
Page 60, my lord.
Page
60.
60.
No, তার আগতে court order টো লাগিব। Before that, my lord, this the petitioner approached before this honorable court, WBC number 2996/2010, page 56.
Can you do it? You can do it, no? I'll just. Page,
Page
Page
56.
56. On basis of that, his name has been placed. His serial number 4.
on the direction, sir. We have set on the direction
Yes.
passed by this court. By order dated 4/12/2014. passed in WBC number 2996 of
2010.
2010.
And his name is placed on
This on the petitioner
Yes.
was placed before the High Power Committee.
page 60.
And page 60, the High Power.
Meeting was held on 16/2/2016.
In this meeting held on 16/2/2016. Then the relevant portion
Yes.
petition A to A. It is page 60. A to A. Okay. Then next para, MSRD, AKDV, and council for the petition has drawn the attention of this court to the order dated 24th September 2012,
Yes.
by which which is annexed as Annexure B to the additional affidavit filed by the petitioner, by which 116 numbers dropped non-teaching staff, within bracket 17 numbers LDA and 99 numbers grade 4 are appointed in defense schools shown against their names staff. The she submits that the case of the petition is similarly
Secreted person.
with the person appearing at serial number 4 in the order dated 24th September 2012, namely Amiruddin.
Amiruddin.
Who was appointed against Uttara Barbida High School. The order dated 24th September 2012 is reproduced here and below. Here there are a number of names, so you don't put all these names. Just make the table. Just put 1, 2, dash, dash, and then serial number 4. That you put the name, and the others you put dash, dash, dash. Okay. That is page 74. B to B. I think that was
74.
okay. Then I will pass the same order.
Yes, ma'am. Highly obliged. Good.
6/10/2017, 43, Lordship can be. On the basis of a resolution, that is also, my lord, retrospective termination order, whether it is permissible under the law, first of all. And secondly, my lord, petitioner was initially appointed in the year 1988. After completion of 20 years, he applied for VRS. But although he has not completed the required qualifying service, so it was not accepted. Page 24, if Lordship may kindly look into rejection order.
I need some time to file affidavit, my lord, because regarding this termination.
You have not filed your affidavit?
No, no, my lord.
2019 matter?
Yes, my lord, because actually, my lord, this matter has not come up after a long time, my lord.
2023 it came up.
Yes, my lord. Thereafter, recently it was listed, my lord.
Only 4 and 5 have submitted their written statement.
Kindly 2 weeks may be given, my lord, I'll file it.
4 and 5.
Only 4 and 5 have submitted their returns. That is principal and governing body.
Colleges.
Yeah.
Mixed it like a kya?
Okay, heard Mr.
My lord, S. Chaudhary.
S. Chowdhury, only counsel for the petition. On request made by Mr.
Yes, yes.
S. Das, Learned Standing Council,
Higher education, my lord.
Higher Education Department, 2 weeks. Further time is allowed to file counter affidavit.
My lord, any fixed date may be given because 2019 letter.
June, list on 20.
Much older.
21.
My lord. My lord, the petitioner here, my lord, may I please, Your
Yes.
Lord, the petitioner here applied for the post of assistant professor in the political science department at Nabojiti College, my lord, pursuant to an advertisement. Subsequently, he sat in the interview, my lord. The selection committee selected him, and the selection has been approved by the governing body of the college. Subsequent to that, my lord, a recommendation was sent to the
Otherwise, Lordship, it will take some time. It's regarding the qualification part. With Lordship, here we have no issue. Otherwise, Lordship, it will take some time, Lordship. So Lordship will fix it for hearing hearing day, Lordship.
On a hearing day?
On a hearing day, it will take time, at least half an hour. I will take at least half an hour.
Okay.
The date may be fixed at the earliest possible time.
Okay, heard Mr.
A.W. Aman.
A.W. Aman, Learned Counsel for the petitioner, also heard Mr. K. Google, Learned Standing Council, Higher Education.
Lordship.
I am
For
for number 3.
For the respondents,
I am for 1 and 2, Lordship.
1 and 2, and Mr.
3, K.U. Ahmed.
K.U. Ahmed, Learned Counsel for the respondent number 3, and MS,
She is on behalf of S. Amal, Lordship.
and Mr. Jamal, Learned Standing Council, UGC for the
Respondent
respondent.
number 4, Lordship.
This matter on 21, 11th
Lordship.
is a hearing day.
Lord June, my lord.
Yeah.
My deeply obliged.
22.
I don't know, parents, the last order, my lord. The finance are supposed to bring some instruction.
And check the last student.
They have not filed any affidavit. my lord.
Finance, who's appearing? Yes, Gogoi. Any instructions?
My lord, they have neglected the matter, my lord. Lordship may kindly peruse the first order,
That is,
832.
From our part, my lord, we
Also
have
raised
already paid
question
the
regarding
provisional pension.
imposition of compensation.
Provisional pension, she is receiving the provisional pension.
My lord, that was, that I have not denied. It is a long pending case, my lord. During the lifetime of my husband, my lord, order has been passed to grant pension, my lord. Thereafter, second litigation, my lord. And my pay is for interest acquired upon all the heads. my lord. And court has observed that why compensation should not be imposed upon them. And in that regard, asked to file them affidavit. That was also not done.
yes, you're not filing your affidavit.
My lord, we'll file our affidavit to that effect, my lord. But the regular pension, my lord, there were some queries raised by the finance department, which we have made the pension.
In that case, my lord, I can have the latest instruction. my lord,
Yes,
but
my lord.
the authorities have done, my lord, finance have done. After the queries have been made. That has been done. You've asked some, you have made some certain queries. The education department, they have clarified those.
Clarified
My
those.
lord, I have no knowledge, my lord, what is the present status? A week time may be given, my lord, I can apply. Okay, because in 9-4 order, nothing has been. Mr.
D. Bora.
D. Bora, learned counsel for the petitioner. Mr. B. Gogol and the standing counsel finance department first for which time to enable him to receive instructions with regard to the status of the regular family pension of the petitioner.
My lord, there is a part of regulation of the service, my lord. That part also be reflected in the.
I'm
In
appealing
the
on behalf of Respondent 7 Accountant General, we have filed affidavit. Because we have returned back which observation did not even receive.
List after 1 week.
And my lord, there is the order of 31/8/23. In that order, it was asked on the next date fixed, the secretary to the Governor of Assam in the Elementary Education Department of Education shall apprise the about the decision regulates the service of the late husband of the petitioner, my lord. They have not replied anything regarding that.
We'll file our affidavit, my lord.
You file your affidavit.
My lord. Lordship may kindly fix the date, short date.
1 week. 10th June.
Then of less.
23.
Yes, Kaushik, have you filed your affidavit?
My lord, the respondent have filed their affidavit, my lord. But they have not objected to anything that we are seeking in the prayer, my lord. Basically, this is for the regular pay scale. The similarly situated people have already got the regular pay scale, my lord. I am only praying for that, my lord. A direction may be given to the respondent authorities, my lord.
What are they saying in the affidavit?
My lord, in the affidavit, they have also agreed. There is nothing substantial in the affidavit. There is one order annexure, my lord. May I take your lordship to the affidavit, my lord?
Yes.
My lord, page number 99 in the affidavit filed with the respondent number in the affidavit in opposition, my lord. By respondent number 4, my lord. Page 99, my lord.
Yes.
My lord, it says Srimati Rekha Vora joined as an assistant teacher against fixed pay of rupees 2,500 per month in BPBM Higher Secondary School on 11/4/2001 by the Office of the Inspector of School SDC Sibsagar, while letter dated so and so dated 31/3/2001. She was allowed to draw her arrear salary by DSC Assam wide number so and so dated 17/2/2021 against a valid sanction post which was lying vacant in Doba Tiniali High School, vice Sri Ripunath Fukon, retired assistant teacher. It may be mentioned that there was no any valid post lying vacant during the period from this to 2016 in BPBM Higher Secondary School. My lord, this annexure that they have submitted, my lord, 3A, my lord. Page number 105. Where they have annexed this, where I have received the arrear salary, my lord. Right now, my lord, I am receiving 15,500 per month. And everyone who was appointed with me, my lord, is now receiving regular pay scale. So that is my only humble submission. That the respondent.
You are getting a fixed pay.
I am getting a fixed pay, my lord.
Yes, sir.
My lord, this matter may be remanded to the director to verify the matter, whether she is eligible
So
to.
what type of an affidavit have you filed? There's nothing here.
Yes.
How can we adjudicate this with petition on the basis of this affidavit. There's nothing here.
Yes,
Who filed this affidavit? Who's respond number 4?
Director, my lord.
Inspector of schools.
No, my lord, director. Director has filed the affidavit, my lord. Mistakenly, it is written as respondent number 4. Actually, it would have respondent number 3.
What is your case?
My lord, my case is done, my lord. I was appointed in 2001. And all the similarly situated teachers have now got regular pay scale. My lord, may I take you through page number 94 of my petition, my lord? Page 94. My lord, may I read, my lord? Paragraph 2, my lord. Where is the
You have earlier approached this court.
No, my lord, this is the similarly situated. I had approached earlier. This is the similarly situated teachers, my lord. Paragraph 2, the claim of the petitioner relates to the benefit of the regular pay, which according to the petitioner, they are entitled to in the view of decision of this court rendered in WPC number 763, 2013 on 16/12/2016, which was affirmed by the division bench of this court in writ appeal number 233, 2017 on 14/6/2019. It has been submitted that the petitioner was initially appointed as assistant teacher after going through the regular process of recruitment on the basis of the advertisement and recommendation made by the competent selection committee in Dhole Bagan Higher Secondary School, Sibsagar district. However, they were initially paid a sum of rupees 2,500, which was enhanced to 15,500 since 2015. It has been submitted that some of the teachers serving in the various schools of the state had approached this court for grant of fixed regular pay, which was allowed by this court in writ petition civil number 763/2013, which was affirmed by the division bench of this court in writ petition number 233/2017, wide order dated 14/6/2019. It has been submitted to the learned counsel for the petitioner that on the basis of the aforesaid decision of this court, many of the teachers of the state have already been granted the regular pay attached to the post of the assistant teacher. It is the said claim they are seeking by filing the present writ petition. In view of the above, this court is of the opinion that the responding authorities can certainly verify the claim of the petitioner if it is found that the petitioner are similarly situated and covered by the decision of this court rendered in the aforesaid cases. They may also be given the said benefit for which the petitioner may file detailed representation individually along with the supporting document before the respondent number 1 and 3 within a period of 15 days from the date of the receipt of the certified copy of this order, and thereafter the respondent number 1 and 3, after making necessary verification, it is found that the petitioners are entitled to the same regular pay as given to the other similarly teachers. They may be afforded the same within a period of 6 weeks from the date of the receipt of such representation submitted by the teachers, madam. I am similarly situated, madam.
Same school? No.
Not same school, not same
How
school.
many petitioners are here?
In
Only one.
this only.
Only one petition.
My lord, one petition.
You initially appointed the assistant teacher.
My lord, my lord.
My lord, page 61, my lord.
Rekha Bora was appointed as an assistant teacher fixed pay basis, man. By the then inspector of school, SDC Shivsagar, by the order number so dated so and she joined in service 11/4/2001.
Okay. Heard Mr.
A.W. Aman.
A.W. Aman and the counsel for the petition. Also heard Mr. U. Sharma, the standing counsel. Secretary,
Secondary
Education Department. For the respondents, 1,
1, 3, 4.
1, 3, and 4. And Mr. H. Aliya, and the standing counsel finance for the respond number 2. Anybody for the principal? No one. I'll pass the same order.
My lord, same order as the last annexure, my lord.
The claim of the petitioner in this writ petition relates to the benefit of regular pay, which according to the petitioner, no, the claim of the petitioner present with petition is for payment of, is for fixation of regular pay scale,
My lord.
to which she is entitled
My lord.
in view of the decision of this court dated 16/12/2016, passed in WBC number 763 of 2013, which was affirmed by the division bench of this court in writ appeal number 233 of 2017 by order dated 14/6/2019. Stop. It is the case of the petitioner that she was initially appointed as an assistant teacher. As an assistant teacher of which school?
My lord,
BPB Memorial HSS.
Where have you stated?
Shivsagar, Sonari, my lord, Sonari.
Where's the name of the school?
My lord, it is BB,
BPB Memorial HSS School.
my lord, BP Borua Memorial High School, BP Borua Memorial Higher Secondary.
Where can I find that?
My lord, it is also in the affidavit filed by the respondent, my lord. Page number 104, my lord. No,
BP.
BPBM Memorial Higher Secondary School.
Appointed as, was initially appointed as assistant teacher in BBBM Higher Secondary School on 11/4/2001, correct?
My lord.
Stop. After, stop, after going through the regular process of recruitment on the basis of recommendation, on the basis of an advertisement and recommendation made by the competent selection committee of BBBM.
My lord.
Of BBBM Higher Secondary School. Stop. However, the petitioner was initially paid the sum of rupees
2,500, my lord.
2,500, which was later on enhanced to rupees
15,500, my lord.
15,500 since 2015. Stop. The further case of the petitioner is that some of the teachers serving in various schools of the state had approached this court for grant of regular, for grant of fixed, for grant of regular pay,
Pay scale, my lord.
which was allowed by this court in WBC number 763 of 2013 by order dated 16/12/2016. Stop. The said order dated 16/12/2016 was affirmed by the division bench of this court in writ appeal number 233 of 2017 by order dated 14/6/2019. Stop. It is submitted by the learned counsel for the petitioner that on the basis of the aforesaid decision of this court, many teachers of the state have already been granted the regular pay attached to the post of assistant teachers. Stop. But accordingly, after hearing the parties, this court is of the opinion that the respondent authorities can verify the claim of the petitioner, and if it is found that the petitioner is similarly situated and covered by the decision of this court rendered in the aforesaid cases, the petitioner may also be given the said benefit for which the petitioner may file a detailed representation along with all supporting documents before the respondent number
3, my lord.
Report of respondent number 1, 1 and 3, my lord.
before the respondent number 1 and 3. Within the period of
My lord, 15 days.
15 days from the date of receipt, from within the period of 15 days from today. Stop. Thereafter, the respondents 1 and 3, after making necessary verification, and if it is found that the petitioner is entitled to the same regular pay as has been given to other similarly situated teachers, the petitioner may be afforded the same within the period of
6 weeks. 8 weeks. 8 weeks, my lord.
My lord, 6 weeks, my lord.
within the
Earlier
period
also
of
6
2 months
2 months.
from the date of receipt of such representation to be submitted by the petition.
My lord.
With the affected observations and directives with petitions.
Deeply obliged.
24,
May it please your lordship. My lord, Director Technical Education Lordships submitted affidavit yesterday, lordships. Lordship, this petitioner is going to file a rejoinder affidavit, lordships. Matter may please be taken up after 10 days, lordships.
Mr. K. Gogol and the Standing Council Higher Education submits that he has filed counter affidavit on 35/2024. Is it on record? No. We just need to verify and place the same on record, if found in order. Stop. Mr. R. Sharma, learned counsel for the petitioner, prays for 2 weeks' time to file reply to the counter affidavit filed by the respondent number
4, lordships.
Respondent number 4. Praise allowed, list after 2 weeks.
Lordships, may I pray for a date, lordships? Fix it.
It will come up, it will come up.
25,
My lord, in this case, finance department has filed an affidavit on 17. This matter relates to, my lord, the petitioner was initially granted 2 increment for his PhD.
Finance department.
Yes, my lord.
Oh, yeah, finance.
But affidavit is, my lord, it is so far the para number 5 and 7 is concerned there. While, my lord, they responded to my para 5 and 10. And also para there 8. And they are saying that this is a responsibility of the DHC for the my fixation of salary with the increment is concerned. They have nothing to do, my lord.
1 minute.
In this case, lordship, we have filed affidavit, lordship. It will require some length of hearing. Even my brother also admitted it will require some length of hearing.
Who appears for respondent for?
For, my lord, they have, it is filed by the affidavit, my lord. It is probably uses Soikia. But he informed me that because of principal, but he has some difficulty today because of his son's, my lord, some problem arises. So he's not
Their
able
part
to-
is
They have
not
admitted
so
that.
much important, lordship. Otherwise, lordship, we have filed affidavit, lordship. This requires some length of hearing. Regarding, lordship, the pay protections and other parties.
Okay, third, Mr. P. Manda, then the counsel for the petition. Also heard Mr. K. Google, then the standing counsel. You are the higher education.
Lordship,
then
lordship,
the
lordship.
Standing counsel, higher education. For respondents, 1,
2 and 3, lordship.
1, 2, and 3.
And the finance, my lord, my lord, later on they were
Finance is a respondent of
number
5.
5, later added as respondent number 5. They have filed
Finance?
Respondent of 5,
Five.
lordship.
Subsequently.
Subsequently,
they
added,
were,
lordship.
my lord, implemented as respondent number 5.
Okay.
This is
As well as Mr. B. Gogoi, then the standing counsel finance department for the respondent. When do you want?
Any day, lordship, in hearing day, lordship.
On request made by the parties, list on, when do you want?
After
13.
after 2 weeks, any
But
hearing day,
date may be fixed, my lord. Otherwise, it will not come, my lord. This is problem.
18th.
18 June, my lord.
Yes.
Master. Master.
26.
My lord, in this case, my lord, a departmental proceeding has been initiated against the petitioner. The hearing was concluded on 22nd of March 24. And my lord, the inquiry officer is, my lord, going to submit the report. But the, my lord, MD, who is the appointing authority, who is the disciplinary authority, he is on election duty, my lord. He will be available only after 5th of June. So I pray the lordship may take up after 2 weeks. My lord. In the meantime, my lord, something will come up against or in favor of the petition.
Okay, heard Mr.
A Islam.
A. Islam, then counsel for the petition. Mr.
After 2 weeks.
Mr. B. Gogoi, then the standing counsel, SSA,
SSA.
submits that departmental proceeding against the petitioner was concluded on 22/3/2024.
Yes, the inquiry is concluded on 22/3/2020.
Okay, don't say
Inquiry is
department,
over.
that the inquiry against the petitioner concluded on 22/3/2024. However, the managing director, isn't it?
Yes, ma'am.
Who is the disciplinary
Director.
However, the mission director, who is the disciplinary authority, is presently on election duty. No orders has been passed till date, correct?
Lordship.
He therefore prays for an accommodation of 2 weeks. Prays a lot, list after 2 weeks.
Much obligation. 27.
May I please the lordship? My lord, in this case, they have filed affidavit on behalf of respondent number 3, and we have also responded to that. What happened in this case, pursuant to a regular selection process. Annexure 1, page 17, ma'am. The selection process was carried out in the year 1996. My lord, advertisement at page 17 annexer 1, my lord.
Yes.
My lord, petitioner appeared, participates in the interview process. Then annexer 2, page 19.
For which post?
My lord, assistant teacher in lower primary LP school, lower primary school. Then my lord, she has submitted the application along with my lord treasury salan, that is annexer 2, page 19 and annexer 2A, page 20. This was accepted and pursuant to a regular selection process, petitioner along with 2 others, my lord, total 3, annexer 2B, page 21.
2B.
2B, page 21 of the my lord, my petition.
Yes.
Serial number 2, my lord, Momi Gogoi. Petitioner herein was appointed on 6/12/1999, my lord, pursuant to a regular selection process. Thereafter, my lord, she was working there in Amulapatti LP School, Sibosak, Hibuagar, my lord. Then, my lord, she was receiving salary. Subsequently, she was sent for, my lord, BTC, Basic Training Center, and he qualified. Then she was provided with regular pay of scale. That is, certificate is annexer 4, page 25. Then regular pay scale of pay was provided to her by page 28, annexer 6. Page 28, annexer 6, my lord. She was provided with regular pay of scale. On completion of her, my lord, the basic training course, completion of her basic training course, she was provided. Then what happened? GPF were deducted from her salary. Then annexer 8, page 30. Pursuant to, then in the meantime, she got married with a person in a different location. And accordingly, she applied for transfer of her, with her own request. And that request was entertained, page 30, annexer 8, my lord. On her own request, Srimati Momi Gogoi, assistant mistress of so-and-so LP school, under the deputy inspector of schools, Sibsagar, is hereby transferred in her own grade of pay and scale to Nimonagor Bagicha LP school under the deputy inspector of school Nazira, block elementary education officer Nazira, with immediate effect. From that point, my lord, what happened? There was some irregular appointment in Nazira, my lord, block. While, my lord, considering the cases of those teachers, my lord, my case was also, my lord, they, my lord, considered as a, my lord, illegal appointee. I have filed affidavit. They have not replied to all that, my lord. They have just my lord, their affidavit. Lord, should kindly see.
After that, what happened?
After that, my lord, she was receiving salary till 2012. She receives her salary.
Which month? 2012?
Yes, my lord.
December?
Yes, my lord. Then, my lord, her salary was withheld for no reason. She's working there till the date of filing this writ petition, my lord, page 32, annexer 9. This is the certificate issued by the headmaster of this school. All along, my lord, respondent side, what happened, my lord? Once they find out that they have no case, my lord, they are taking time from 17/11/23. Until date, they have not filed any further response, my lord. And my case is a clear-cut case, my lord, in which, my lord, similarly situated person appointed with the petitioner in page 21 are receiving salary. They are, because of my transfer, due to my marriage, I am not salary, receiving my salary. In their affidavit, they have not said anything adverse against me, my lord.
At your lordship, we have filed our affidavit, my lord, as per the last order, my lord, whether she is in service or not, my lord. That instruction, I have not
Is
received.
she still serving now?
Yes, ma'am. So some time may be allowed, my lord.
My lord, one along from, lordship kindly see order sheet, my lord. From 1711, they are taking time with one ground or the other.
There is some confusion whether.
Repeated times, repeatedly, my lord, times were granted, my lord.
Whether she is a regular employee or she is a illegal or irregular, my lord. So kindly some.
Oh,
time
they
may be
face,
allowed.
they have filed affidavit, my lord. What more they want, my lord? They have filed affidavit, my lord.
Yes.
They have filed affidavit. Their affidavit will speak itself, my
We
lord.
need some time. sir.
This is not
We
the
need
solution,
some
my lord,
time.
by giving time, my lord.
Otherwise, the action may be given.
I'll give you a short time. After that, there will be no time. There will be no adjournment on the next date.
Because
the
petitioner
court
before your
discussion
lordship is
will-
without salary, my lord.
Yes.
Yes, my lord.
My lord, 7 days, my lord.
No, my lord. 10 days.
But GMA Chowdhury learned counsel for the petition. MS N Fukan. Learned Standing Council Elementary Education Department shall apprise this court as to whether the petitioner is still serving.
As well as, my lord, Annex Act 21B, the similarly situated person and whether the similarly situated person are getting salary. Annex Act-
1 minute.
my lord. 21B, page 21, Annex Act 2B. Page 21.
Otherwise, my lord, send it back to the department.
That will not help the petitioner.
Page 21.
Of whether the petitioner is still serving. In 194 number, Nimona Gora Bagan LP School, under the Deputy Inspector of Schools Nazira and Block Elementary Education Officer Nazira. After February 2012. Stop. List the matter again on
After 2 weeks, my lord.
14th of June.
My lord.
Lordship.
It is made clear that there shall be no adjournment on the next day.
My lord, so far the Annex Act 21, they should make a clarification.
That is automatically that is no.
Lordship.
Development.
28.
As per my instruction, petitioner received the arrears salary. Here petitioner claiming, file this petition for claiming arrears.
Yes, you have any instructions whether the other petitioners have received the arrest salary? How many petitioners are here?
Total 11.
13 petitioner.
13 numbers of petitioners.
Yes, what is your
Here, regarding the persons who work under the Director of Elementary Education, petitioner number 1, he has received the area salary. Remaining, my lord,
Petition number 4 and 9 already received their salaries, lordship. And earlier,
as per my instruction, my lord, petitioner number 1 also received, my lord. And my lord,
No, no. How are you just picking them up piecemeal?
my lord, I have received this instruction, my lord. Yesterday.
Let us see the instruction.
Only here.
If I may just bring to your lordship's notice, my lord, what has happened in this case, I am appearing for the accountant general. My lord, probably petition number 4 and 9, they have received their area salaries. So far as the other petitioners are concerned, my lord, probably their schools have got amalgamated with high secondary school, high school or high secondary school. So now their drawing and dispersing authorities are different, my lord. So because of that, probably the other petitioners have not received their salaries, and herein, my lord, the respondents are only the Director of Commission Secretary of Education, Elementary Department. Now probably the petitioners have to implement the
Already
Director of
implemented.
Secondary Education as party, probably.
secondary education has been
Lucid.
last.
Complete position. I'm told that they have already implemented the Director of Secondary Education as party respondent. I'm not sure, my lord.
Amended cost title also filed, lordship.
Secondary, section, the secondary, elementary, list
Yes, secondary who appears.
Then with the 28.
28. Lordship, today we have missed the item because our name is not shown in the cause list. Only elementary education is shown. Item 28. Lordship may kindly fix it on next week, any date, Lordship. I will get it.
Heard MS?
S. Patwari.
Yes, Patwari, then counsel for the petition.
Again.
It is a limited public.
On request made by Mr. S.M.T. Chishti, then a second, standing counsel, secondary education department. When do you want?
2 weeks, Lordship, any date.
This the matter on 12th,
Only register may show our name, Lordship.
on 12th of June, to enable him to receive instructions. Registry is also directed to reflect the name of the standing
Secondary
counsel, secondary education.
My presence may be recorded, can you?
Mr.
B. Sharma.
D. Sharma and the standing counsel affairs for the accountant general.
29, 30, 31.
Make leisure losses. In this case, my lord, petitioner before your lawsuit, non-provincialization of the services of the petitioner, where the similarly situated person have already been, my lord, regularized. 90 candidates were left out, my lord. There is an order passed by this honorable court, my lord, that is, kindly peruse the order, my lord.
Page, date.
Order dated. Interesting, yeah. It's professional. Order dated 7/9/2023. No, I do. No. Your lordship also passed several lordships earlier. Good hola. Oh, yes, my lord. 22/11/2023. It is stated by the Mr. B. Chaudhuri, Learned Counsel for the respondents in the BTC, that some of the petitioners have been granted the benefit of regularization that they have been claimed for, while in respect of some of the other petitioner, it is still under consideration. Respondents in the BTC make a specific statement before the court as to whether they intend to give the benefit of regularization to the other petitioner, and they have any objection to suspend. They have filed affidavit, and they admitted that they would like to regularize the services of the petition.
Not so far as first verification is concerned, from the director side, one affidavit is already there. But today morning, when I talked to the authority lordship, they say it is last round of consideration, lordship.
So Lordship, matters also listed after a long gap, Lordship. Lordship will allow me some time, Lordship. In the meantime, I will have some instruction.
My lord, I have received one letter, my lord, 10th January 2024. Would you like to peruse?
What letter is this?
এখন দিয়ক।
I'm aware about this. This is the
হয় নেকি?
query made by the
Yes,
secretary.
my lord, and it is
So
shown the vacancy of the position of the.
Okay, heard Miss MSK David and the council for the petition. On request made by Mr. P. Nayak, London Standing Council, BTC.
BTC, Lord.
How much time?
Sorry,
Oh.
4 weeks.
My lord, lordship kindly fix the matter after 1 month or 2 months. In the meantime, my lord, they should regularize the services of the petitioner as per affidavit filed by the.
Lordship, Lord, may not say regularize, Lordship.
4 weeks time
Consideration
is allowed to enable him to receive instructions.
Lord.
You want a date fix?
Yes, lordship.
It will be in July,
July, yes.
based on 17th July.
Highly obliged. হ'ব দিয়া না?
32.
BP has been initiated against the petitioner, my lord.
Lord, I am not on that, my lord. My lord, here in this case, Lordship kindly will look page 21, my lord. Page 21, my lord. This is the suspension order dated 2nd July 2022. This humble petitioner was placed under suspension by the district elementary education officer Hailakandi. Hereafter, my lord, he approached before this honorable court, and this honorable court was pleased to direct the respondent to, my lord, reinstate him, my lord. And this judgment and order, starting from page 22, annexure 6. And thereafter, my lord, in compliance with those judgments, my lord, by my lord, page 30, annexure 8, this petitioner was reinstated, my lord. But my limited grievance is that, my lord, as per this suspension order, my lord, he was paid only 50% of his salary, my lord. Other 25% is not paid, my lord. Therefore, lordship kindly may be pleased to have a look in the prayer part of the writ petition, page 11. Here, my lord, prayer number 2, Roman 2, my lord, to pay balance monthly salary of the petitioner, my lord. From, my lord, a limited period, July to March 2023, my lord, till his reinstatement, my lord. And some other, my lord, money he spent while he was working as headmaster for midday meal, my lord, 40,000 and odds amount, my lord. This is also pending, my lord. So far, my lord, they have not filed affidavit, my lord. With all respect, my lord, I am saying, my lord, matter may be relegated to the competent, my lord,
No,
respondent.
they've already initiated department.
My lord, my
You
lord,
file your affidavit.
my lord.
My lord,
Will be
departmental proceeding is okay, my lord, but my 25% is entitled, my lord.
Well, here
So-
regarding para number 3, my lord, this is against the headmaster, man. He's claiming.
Headmaster also entered appearance, my lord, earlier.
Whatever it is,
My lord,
you place it on
My-
by way of an affidavit, so the petitioner also will know what is going on.
my lord. I'll
But
bring
M.
the-
Bhargav and then the council for the petitioner. Mr. B.K. Bora, then the standing council,
Elementary education.
elementary education is allowed 2 weeks time.
My lord,
My lord.
kindly, my lord, he has stated that, my lord, the he is initiated, that may be kindly recorded, my lord.
Okay, Mr. B.K. Bora, then the standing council, elementary education department submits that the departmental proceeding has already been initiated against the petitioner. And prays for 2 weeks time to file affidavit.
My lord.
Praise allowed. List after 2 weeks.
I'm paying for
Mr. A.K. Datta, Leonard Council appears for the respond number 6.
6 and 7.
Huh?
6 and 7.
6 and 7.
My lord, kindly, my lord, any convenient date may be fixed, my lord.
It will come up.
Obliged.
3.
Diploma.
May it please your lordship. This matter is with regard to a transfer under the safety and security of the petitioner. The petitioner, who is a lady, has applied for transfer under the safety and security, which is under the Assam Elementary Education Secondary School Teachers Regulation of Posting and Transfer Act 2020. What has happened, your lordship? The lady who was at that point of time pregnant, now she has a very small kid. So she was posted in a particular place in Barpeta district, where she had some problem with safety and security of herself and her newborn kid, your lordship. So she applied for the safety and security. I'll just give a gist of the matter. It's for transfer under the safety and security. At that point of time, your lordship, she was transferred and posted in Kamrup district under that category, safety and security, and posted in a particular school. When she came to join in the school, she was not allowed to join. And the person who has been transferred from the Kamrup to that Barpeta school did not go and came before this honorable court challenging the order of transfer. Now, this honorable court has interfered with that particular order of transfer and setting aside that on the ground that the approval in these cases, approval is with regard to the approval that has to be taken from the authority concerned, which was not taken, therefore it is illegal. Therefore, the court has remanded back the matter to the authorities to reassess everything and then pass an order. Now, that order has not been passed, and I have come before your lordship thereafter, coming to say that they have not passed this order. Therefore, your lordship will continue. I'll take your lordship first to the order of this honorable court, earlier order, that will clear everything. That order your lordship will find at page 39. It starts from 39, your lordship. I'll not read the whole order. Lordship will kindly take page 51. Operative part, page 51, paragraph 17. The learned counsel for the petitioner so-and-so submitted that apart from applying in the manual mode, the said petitioner is also applied in the online mode and the application number is so-and-so. Taking into account the application so made both on the manual mode as well as the online mode in WPC so-and-so, and further taking into consideration that ground exists for transfer in terms of Rule 9, as has been certified by the Additional Deputy Commissioner, Barpeta District, in its certificate dated so-and-so, this court directs the Deputy Commissioner of the Barpeta District to verify as to whether any grounds mentioned in Section 9 still exist in case of the petitioner in WPC so-and-so, and if it is so exist, refer the same to the competent authority under Section 5(2) of the Act of 2020, and the competent authority thereupon is further directed, upon such reference being made by the Deputy Commissioner, to consider the proposal of the petition. In the eventuality the competent authority deems fit, the said competent authority shall recommend to the appointing authority for issuance of the transfer order. The appointing authority, upon being satisfied with the recommendation, shall pass appropriate order for transfer. The said exercise may be carried out in terms of Section 9 of the Act of 2020 or Rule 11 of the Rules of 2022 as expeditiously as possible, not later than 45 days from the date of certified copy of the order. Now, your lordship, what has happened? Thereafter, I made the application again for reconsideration of the same.
You filed this 806.
Yes. Earlier, this was filed. And the court said that to reconsider because the approval by the appropriate authority was not given. So therefore, the Deputy Commissioner was directed to put it before the approval authority and thereafter do the needful, your lordship, within 45 days. So this is the second part. First part, the first transfer order was set aside by this honorable. Now, after this, I again made an application to the concerned authority. The concerned authority accepted our application and then given me the certificate of your lordship, the issue of safety and security. That your lordship will, the application is at 53, and then your lordship will find the order from the Deputy Commissioner, which is at page 56. This was by the Deputy Commissioner, Additional Deputy Commissioner, submission of page 56, your lordship. Submission of certified copy of safety and security certificate issued to Sudarshana Smith. So on the basis of the High Court order, this was submitted, but there was an issue. The said particular certificate could not be uploaded at that point of time. So thereafter, again, we filed many applications, your lordship. I'm not going through the applications. Then in page 62, finally it was uploaded, your lordship. Regarding uploading, page 62, regarding uploading of safety and security certificate issued to Sudarshana Badsa. After this, your lordship, this was uploaded to the portal of the Secretary, Department of School Education, Mission Director, everyone. Now this was after uploading this, I have to be transferred to the concerned place from there on the basis of safety and security. One thing has been confirmed that the safety and security of this particular person is in danger. Therefore, she has to be transferred. So that was the issue. So after that, they offered us. The authorities now did not issue a transfer order directly. Now they issued a letter to me saying that there are two vacant posts. One is in Dibrugarh district, one is in Morigaon district. You go to either two of them. But I said, no, I want that the earlier place should be given to me where I was earlier transferred. Though at that point of time, the transfer was challenged and the challenge was upheld only on the ground that the approval was not taken. Now, this time the approval has been taken. Therefore, kindly pass the transfer order. Thereafter, they have not issued any transfer order till date. This is basically the case. Now, in the affidavit in opposition, they came up and stated that those two posts which they offered in Dibrugarh and Morigaon, those two have also been filled up. Now, what happens? I have to be transferred because the safety and security certificate has been granted. So one thing is very clear that there is safety and security concern for the particular person that is there. Second part, your lordship, I have to be transferred. Now they can transfer me into Kamrup and the nearby districts which I offered in my letter. So that they have to consider and pass an order. That's basically what I want. As of now, that is basically my case. I'm not going into the rules.
Nayak. Now what you're saying is that there are no more vacancies.
Right now, no, there is no vacancy.
So you look for some vacancy, make come up with a suggestion.
Yes,
And
on last date, last date also that direction was issued, not it.
This court
On
issued
last date, we informed that no vacancies are available in the trade to which he belongs. Lord. And as per the rules, Lord said, such transfer can be considered only if there is vacancy, Lord. This is rule 11, Lordship.
No, now you are saying there are no vacancies.
Lordship.
But now the safety and security certificate has already been issued to the petitioner. It is also uploaded.
And she was given option also, Lordship. At that point of time, two vacancies were.
Now after that option was given, now you have come with an affidavit.
Now, in the affidavit and in the speaking order also, we have stated, whenever there is a vacancy in the Kamrup or adjoining district, Lordship, if she applies, then we will definitely consider her application. That is the stand we have taken in the speaking order. Now, we have to wait for vacancies. That is the.
How long is the petitioner going to wait for the
option was given to her?
That was there. There's no doubt. That was in Dibrugarh and Morigaon.
She has only a specific place, Lordship, Bajara in the Kamrup district. That is a specific demand, Lord.
No, I have stated either in Kamrup and the adjoining districts.
Bajara, Lord. It has been specifically mentioned.
No, that may have been mentioned because earlier she was transferred to that school.
Like if that light treat was definitely there, Lordship, then she should have joined either in Dibrugarh or in Morigaon, Lordship. She declined, Lordship.
No, there were two grounds here. Because she had also.
Are there any vacancies right now?
Right now, no vacancies are there. So for
Are you sure? Or
that instruction I have taken.
even in Kamrup district?
Nowhere, not. No vacancies are there. But whenever there will arise any vacancy in Kamrup or adjoining district, Lordship, we'll definitely consider her case. That is the assurance given in the speaking order also. In terms of the court's order, once speaking order has been passed, that lines has been added in that speaking. So it will be considered, but vacancy is the issue. This should have joined, Lord.
No, whatever has gone. Now at this stage, your lordship, I also don't want to linger the matter for long
No,
because this is also an issue of safety and security, how long a person will survive. I don't know on this, under this condition. So even I don't want to linger the matter. If they would like to consider, at least if your lordship, to that extent, some order can be passed by your lordship, let them consider afresh everything, and if there is any vacancy nearby.
Last time, Lordship, we transferred her to a post in a Kamrup district, Lordship. But the person holding that post, he approached its honorable court, and that is why her transfer order was interfered.
Yes.
That is the reason, Lordship. Now, even now also, Lordship, we can transfer her to some post, Lordship, but that person will again come, Lordship. And most importantly, Lordship, persons who are holding posts in the Kamrup or adjoining district, Lordship, they join those posts on the basis of their merit position, Lordship, on preference.
No, what happened on the last occasion when that person challenged that? There was a loophole in the transfer order.
No, that's fine.
So that loophole court set aside saying that no, now you again reassess and pass the order if there is that particular safety and security. Now they have found, yes, safety security is still there and everything is there, but she was transferred to some, she was not transferred. In fact, transfer order was not passed. She was given an option.
You're given two options.
Two options. So when she said, no, these two options I would not do, kindly give me here. So whichever earlier school was again preferred by her.
Why don't you take some instruction whether there will be any vacancies in the near future?
I can take, Lordship, that is not.
So that this court can pass some order, just saying that, sending it back to the authorities, saying as and when vacancy are, these
Lordship,
things will
never happen.
It will never happen.
That direction your Lordship can pass, Lordship. In my affidavit, Lordship,
When the petitioner is having a
their actual problem is that if she is transferred to any other non-vacant place where, or someone else will be transferred to that place that is in some sore area. So people will not go, they will come and before this court and challenge that. But that is actually that ground or reason is also there. I appreciate that. True. Everybody will come.
We can make such transfer only vacancies are there, Lordship. It is
No, that part I've seen. Can you just check up whether she can be accommodated in any place?
Lordship, may kindly see paragraph page 73 of my affidavit. Lordship can dispose of this petition. Page 73, Lord.
Yes.
Lordship, may kindly see the second paragraph. In view of the above explained facts and circumstances, the mission director, Samagra Shiksha Ashram, is of the opinion that as there is no vacancy able within the district of Kamrup or Kamrup Metro at this stage, transfer of the writ petitioner to any school within these two districts is not possible. However, if in future any vacancy arises in the same trade to which the writ petitioner belongs within the districts of Kamrup or Kamrup Metro, then she may apply for transfer against such vacancies as per the norms. In this connection, a speaking order dated 18/7/2023 was passed by the authority and the same has been duly communicated to the petitioner. So we have complied on this position, Lordship, taken by the department. As
that order?
That order is a speaking order, Lordship. Inadvertently, this was not annexed, Lordship. Mark portion, Lordship. This is the speaking order.
Do you want to this court to dispose of this on the basis of this statement?
In Lordship can do one thing, your Lordship. If your Lordship disposes of, at least one thing your Lordship may mark it that this petitioner, maybe what they will do if any vacancies exist or some transfer or anything happens, they may consider other also. At least she should be given preference in this case. That at least has to be incorporated. Then at least in the next, because what happens if your Lordship goes through Rule 9, which the Honorable Court in the order specifies, it says that you have to do it immediately. So when there is some safety and security, if it is not done immediately, this is on the act.
No, it was
And
done.
and 11 and Rule 11 says vacancy. Now the act says you have to do it immediately, and the rule says vacancy, obviously act will go, once the act says it has to be done by the authority immediately, that has the preference over the rules, normally. That what, I don't have to explain that. That is always there. That is why on the basis of Rule 9, Your Lordship, this is what I wanted, that at best, under Rule 9, we will make, if required, we'll again, there is not necessary for any further applications. We have given the application. The authorities have issued the letter certificate of, Your Lordship, this particular issue of safety and security. So under these conditions, I need not again file application.
Petitioner wants only Kamrup.
No, Kamrup and adjoining this,
No,
because
but
Bezera was
school
issued.
has been mentioned.
No,
Lord. Even my
Bezera
affidavit
school was,
also I have mentioned.
no, I'm just making the submission. Bezera school was specifically mentioned on the ground that she was transferred to that school earlier. That is why she wanted that you again transfer me to the said school, as per Rule 9. So the Rule 9 says you have to be transferred. It doesn't say that it has to be vacant. Sorry, Rule 9, I'm saying it's a Section 9 of the Act. Rule 9 says that if there is a vacancy. So these are the only issues.
Is there any vacancy in the adjoining areas of Kamrup?
Last date, Lordship, my instruction was no such vacancies are available.
Can you just check up one
Lordship-
more time?
Lordship, if direct Lordship, definitely I will take that instruction. If in the meantime, any vacancy arose.
I'll give you a short date.
Lordship,
We don't want to keep this type of small matters lingering for
Yes,
unnecessary
exactly.
purpose.
Lordship, I will take that.
They are also not averse to it, but there are some difficulties from their side also,
I-
and some difficulties from the petitioner also.
Third Vice Manan, Learned Counsel for the petition. Mr. P. Nayak, Learned Standing Counsel, SSA,
SSA, Lord.
shall take instructions as to whether there's any vacancies in the adjoining districts of Kamrup and Kamrup with the bracket M. I'll give you 1 week time,
Lordship, Lord.
please, on 10th or 11th
10, 11, any date, Lord. I will receive that.
on 11th. That day will dispose it
Yes.
of.
Whichever way it goes. Much obliged.
34.
You take it back.
Lordship.
Give it back.
Wait, please, Lordship. Lordship, this matter can be closed. The petition has been reinstated, Lordship, on as per order dated 1/5. Means
Correct?
I have no instruction, Lordship.
Can you close the matter?
If reinstated, I have no objection.
Reinstated. Reinstated.
What, Mr.
Edition.
K.T. Sharma, Learned Counsel for the petition. Stop. Any disciplinary proceeding initiated?
At that moment, that instruction, but otherwise he's been reinstated.
Okay. The petitioner, due to involvement in some illegal activities, was placed under suspension by an order dated 28/3/2023, correct? Issued by the Director of Elementary Education, Assam. He was serving as what?
Principal.
Don't say that. The petitioner was serving as headmaster of 5 number Barsitani MB school. Was placed under suspension by an order dated 28/3/2023, issued by the Director of Elementary Education, Assam. Stop. By the said order, petitioner was also allowed to draw the admissible subsistence allowances during the period of the suspension. Stop. The petitioner made a representation dated 12/7/2023 before the Director of Elementary Education Assam to withdraw the order dated 28/3/2023 by which the petitioner was placed under suspension and to reinstate him back in service. Stop. The case of the petitioner is that the respondent authority in the Directorate of Elementary Education Assam have not issued any show cause notice nor initiated any disciplinary proceeding against the petition. Stop. Para. Today, when the matter is called up, Mr. A. Fukan, learned standing counsel,
Elementary.
Elementary Education Department, has produced an order dated 1/5/2024 issued by the Director Elementary Education Assam, by which the petitioner has been reinstated as assistant teacher till the finalization of departmental proceeding in his original place with immediate effect. Stop. Para. Considering the 1 minute. Aware, I said, no departmental proceeding has also been initiated. The present writ petition continue as is filed. Praying for direction to quash and set aside the suspension order dated 28/3/2023. Correct. Stop. After that, you say Mr. Para. Considering the order dated 1/5/2024 by which the petitioner has been reinstated as assistant teacher till finalization of the departmental proceeding. This court is of the consent opinion that nothing survives in the present writ petition. Accordingly, this writ petition is closed. The order dated 1/5/2024 is placed on report.
Lordship, 5 number Barsidhan MP school. Name of the school, Lordship. 5 number.
What did I say?
No, I have.
5 number Barsidani MB school.
Yes,
correct?
yes.
Indicate the identity for aspirant number 3, Lord.
Oh, on top, heard so and so, also heard MS DD Barman, learned government advocate.
Yeah.
For the respondent number 3.
35.
May it please, your Lordship. Also, this matter pertains to a non-payment of salary with regard to the petitioner. Petitioner has superannuated.
My lord, I have received an instruction, my lord. The director has asked a area proposal from the inspector of school. I've talked to the inspector of schools also. The area proposal will be sent today, my lord. Such will take, adjourn it for 3 weeks, my lord. Possibly by that time it will.
Page 47.
Heard Mr.
K.M. Mohanta.
K.M. Monda, learned counsel for the petition. Mr. B. Kaushik, learned standing counsel. Secretary
Secretary.
Education Department. Submits that the Director of Secondary Education has written to the Inspector of Schools,
Kamrup Metro, my lord.
Kamrup Metro, to submit the
Proposal, my lord, in the proper
proposal
format.
for
proposal for area salary.
for area salary in respect of the petition. He also submits that the proposal for area salary would be sent by the inspector of schools within the course of the day.
No.
Stop. Within the course of the day, and therefore placed for 3 weeks' time to enable him to obtain updated instructions. Please allowed, please after 3
Great,
weeks.
Date may be fixed, your lordship. Date may be fixed.
Please give a date up to 3 weeks.
Please, your lordship.
26. 26. 36.
May it please, your lordship. Lordship, in this case, petitioners' names were recommended by the district scrutiny committee to the state level scrutiny committee for provincialization. My lord, thereafter, petitioner approach to this honorable court, my lord. And court directed, honorable court directed, that is page 64, my lord. Page 64, 66 is the relevant portion. To consider representation, my lord. After that, my lord, page 67. Page 66. Page 67, my lord, relevant portion, page 68. After the director passed this on impugned order, saying that the my lord, last paragraph decision, my lord, got it. The name of petitioner school, new so-and-so school, was not recommended by the SLC due to no valid land documents, deeds, Zamabandi, etc., to prove the land before 1/1/2006, as per clause 3 of clause 3, subclause 3 of the Act 2017. Now, my lord, as per the section 3 of section 3 of 17 Act, the school must have land before 1/1/2006. Now, my lord, my page 32 is the draft CETA copy, my lord, of the school. Here it shows that the school has land from 1984, government khas land, my lord. The school is possessing government land, measuring 2 biga, 0 kata 10 lesser, since 1984. Then land holding certificate, page 36. Issued by the assistant settlement officer. It is also says that this is to certify then so plot of
Affidavit
land.
has come?
My lord, no.
Yes, Fukan?
Lordship, we are awaiting instructions a lot in this matter. Some time will be required, my lord.
Even on the basis of the, my case is that, my lord, the land.
Received a letter, my lord, in the, that some accommodation may be required for taking the thing.
Okay, that Mr. Ahmad Kandakar, and also Mr. Fukan, and standing counsel, secretary. Elementary education department. Is allowed 2 weeks time.
2 weeks.
To receive instructions and file a. Please, up to 2 weeks.
May I say date, my lord? Say date.
That is very difficult. 20 May, 20 April, 20 June.
20 June. I am always.
Wait, please. My lord. One more.
May I please, your lordship? Lordship, kindly.
My lord, your lordship, 37, 38, and 39 is out of similar facts and circumstances. Your lordship would be pleased to take 38 first. Shalom.
1949.
Yes, my lord. 1949.
Readings are all complete.
Greetings, sir, complete, my lord. Now I place before your lordship your lordship would be pleased to see order dated 6/4/2022. Case is regarding provincialization, my lord. 7 and 8 was provincialized.
1 minute, 6.
6/4/2022.
Hmm.
Here, my lord, your lordship was pleased to call for the record.
Yes.
Now, your lordship, I'm placing before your lordship order dated, again order dated 15/11/2022.
Hmm.
Here, your lordship again call for the record, and in the last but one paragraph, my lord, your lordship referred to the order dated 6/4/22. Here it is said, failing who is the said authority shall have to remain personally present before the court on the said date so fixed at 10:30 a.m. and shall also apprise the court as to why the appropriate action against her should not be initiated for violating the order dated 6/4/2022. Record was not produced. That is why your lordship passed this order. And again, your lordship passed another order.
Calling for records.
My lord, another order, my lord, that last sentence is given. I am referring to that, my lord. Your lordship will be pleased to see order dated 12/5/2023.
Hmm.
Here, your lordship, I am referring to paragraph 8 of that order. That has been narrated, my lord. This order record was not produced. Under such circumstances, the respective councils appearing for the Deputy Commissioner Dhubri as well for Director Elementary Education are given on final opportunity to complete their instructions and produce their relevant records in support of their contentions as to which proposal containing the names of teachers were received from the office of the Deputy Commissioner Dhubri was put up before the competent authorities and as to how the RTI different document presently stated to be not available in the record of the Deputy Commissioner Dhubri, as has been furnished to respondent number 7 and 8. In response to their application under RTI, instruction be placed before this court on the next date fixed 25th of May 2010. Depending on the instructions that may be placed before this court, further necessary order may be passed. Accordingly, let the matter listed. So, my lord, here what happened? District level selection committee, my lord, recommended the name of the petitioner for provincialization. But in the state level, my lord, what happened? By manipulation the entire records, they provincialized the service of respondent number 7 and 8. Now what happened, my lord? If the original records come, some officers will be in problem. Some officers, maybe district level, maybe state level. That is why, my lord, your lordship would be pleased to see from 2022, every time this Honorable High Court saying that place the original records, they are not placing. We are in 2024, my lord. Every time they are not placing the records. Time after time they are taken. So that is why, my lord, it's playing with the High Court's order, my lord. Why they did not place?
Yes, who appears?
Every time they are taking time, records is not produced.
Lord, we are appearing for respondent, Lord, respondent number 7 and 8.
in the present writ petition, my friend representing, my lord. And my lord, writ petition number, my lord, 126, 2024, the item number 37 for the petitioner matter. Now, in this case, lordship will find record was produced before the honorable court, and that has been verified by the honorable court. It is, and it was found in order. Lordship kindly see at page 37.
Page?
Page 37, in WPC number 126 of 2024.
On 26/10/2020, the original record is produced, Lordship, before the honorable court.
By which order?
Lordship will find at page 37 in WPC number, my lord, 126 of 2024.
Order date.
Yes, yes, 37. no? Order date, my lordship will find, my lord, at page 12/10/2023. Page 40. Lordship will find.
Page 40?
Page 40
Oh,
Item number?
of, my lord, WPC number 126 of 2024.
Item number.
Item 37. That is. Item 37, my lord. Page 40, lordship will find.
yes.
Yes. Now,
So,
the original record was.
may I please before your lordship? This is regarding, I think number 30. This is regarding supply of some documents to the client of my friend. And when your lordship called for the records, it was found that actually RTI reply was filed and RTI document was given from records. And that record was manipulated record. Anyhow, your lordship got this, that actually RTI documents were given from the record.
Are you the respondent 7 and 8 in the, in this writ petition 126?
Yeah.
Yes.
Yes, ma'am. Now, your lordship, during pendency of this item number 38 and 39, that respondent number 7 has been terminated from service. Terminated from service. And ultimately, my lord, item number 37 has been filed. Now, my humble submission before your lordship will take item number 38.
I'm on
A
38.
detail we have to go. Because, my lord, here DSC recommended petitioner's name. But service of respondent number 7 and 8 was provincialized. On what basis? That is the case. And if the original record is all right, my lord, now question arises, why service of respondent number 7 was terminated? If it is original record, why respondent number 7 service is terminated? Because, my lord, the state level committed wrong. Now, your lordship, let us take first the item number 38. That's the original case, my lord. Your lordship, one after another, let us go. And this should be come to a final finding, my lord.
No, are you taking up the hearing or you want the records?
My lord.
You want them to produce the records or you are
My
proceeding
lord,
with the
they
hearing?
will not produce the record. Every time they are.
They produce the records.
No, my lord, that record is not produced. That is why my case, my lord. That record is not produced.
You have the records.
Yes.
You have the
Let them-
records.
Yes, my lord, let them produce original record. District level and state level. District level and state level record may be produced.
We have received, Lordship,
My lord.
but it is in our office, Lordship.
Yes, let them produce.
And
If
the
the
state-
record is available.
State level?
Yeah. Some records have come, some has not come.
You produce the records.
After 2 years also, this
then
is
we'll
not done.
consider the matter. Yes.
But your lordship would be pleased to see, your lordship given last sums. Thereafter also they did.
They said they have.
Again,
the
they will
rec-
not produce.
they have
Yes,
the
my lord,
records
that,
in
that
the
may be
office.
recorded. That may be the last sums. Again, they will say,
Lord M.U.
record is
Mandal,
not in proper manner.
Counsel for the petitioner in WBC number 126 of 2024. And Mr. M.A. Sheikh, learned counsel for petitioner in WBC number 1949 of 2021 and WBC 2083 of 2021. Stop. M.S. D.D. Barman, learned government advocate, appearing for the respond respond number 3.
Deputy Commissioner.
And Mr. B. Talukdar, learned standing counsel, Elementary Education Department, shall produce the records. List on Monday. You want it on Monday?
My lord, it may be specific. District level
Shall
scrutiny
produce the
committee.
records of the district level scrutiny committee
Already there.
and the state level scrutiny committee.
Yes, my
List on.
lord. ঠিক আছে?
fifth.
হ্যাঁ? Wednesday, my lord. Obliged.
May it please, your lordship.
Yeah, affidavit not yet come.
My lord, they have filed their affidavit today, my lord.
Hmm.
They have received the copy. And my lord, in the affidavit, the stand is this. My lord, my case for promotion has not been considered. Because, my lord, there is a pendency of writ petition number 7626 of 2022. In that writ petition, the petitioner of 7626 of 2022 challenged the gradation list of the incumbent of the statistical assistant in the SCRT. I was the employee of SCRT, my lord. I joined SCRT as statistical assistant, but my lord, I have been promoted to there is a scheme, my lord, to strengthen of elementary education. And I have been promoted to the post of research assistant, my lord. Now, my lord, as per that scheme, the service order was enacted of 2017. As per that service order, I am eligible for being considered for promotion on next higher post. And my lord, in this writ petition, there's a stay order staying the operation of gradation list. At that moment, my lord, I came before lordships by filing IA. And that order lordship will find at page 44 of my writ petition.
Yes.
My lord, this order was passed in presence of the respondents, my lord. And my lord, kindly turn to page 47. Last paragraph. In view of the above, it is clarified that the interim order dated 30/11/2022 passed in a writ petition shall not affect the service benefits which may accrue to the applicant, that is me, my lord, who is discharging his service as research assistant under the centrally sponsored scheme. That means, my lord, that order, that stay order passed in other writ petition, that will not come into play in respect of my promotion. But that stand is this, my lord, due to pendency of this writ petition, they cannot consider my case for promotion, my lord.
Where's the affidavit? When did you file it?
I received today, my lord. Today afternoon, you have received it. My lord, WBC number I just checked up, 7626 of 2022 is fixed on 6th, my lord, 6th of June. So, my lord, may I pray that this matter may also fixed on 6th of June, my lord. Because, my lord, the person is going to be retired on January, my lord.
Mr. P. Nayak, learned standing counsel, SCRT, submits that he has filed affidavit in opposition this morning. Stop. Registry to verify and place the same on record. Stop. List this matter along with WBC number
7626 of 2022,
7626 of 2022 on
6th of June, my lord.
6.
And deeply obliged.
47.
May it please, your lordship.
Hmm.
This matter relates to non-provincialization of the service of the petitioner, your lordship. And
Now, this petitioner, he was appointed on 23/12/1993 as the founding teacher of the school, your lordship. It is an ME school. It was at that time in the bencher stage, your lordship. Service of the respondent number 6 is complete, your lordship. As per office note dated 2/4/2024.
Yes.
In this case, your lordship, there was also an earlier round of litigation. And your lordship was pleased to send the matter to the second appellate authority, that is the government. And they have again rejected, your lordship, on the ground that the name of the
Affidavit, are you filing or not?
The,
You are not filing your affidavit.
they have filed, this writ petition challenging the speaking order.
speaking order, your lordship, the name of the petition was duly forwarded by the district scrutiny committee that I have annexed at page number 23. But they have rejected on the ground that the name was not recommended by the district scrutiny committee, your lordship. Otherwise, your lordship, the petitioner is the senior most teacher. And he ought to have been provincialized, your lordship.
Who is the recommendation by the district scrutiny committee?
Lordship, I am free. I have obtained it through RTI, your lordship. Page 23 is the RTI reply given by the district elementary education officer.
Page 23.
23. 23, lordship.
Where is the page? Page, relevant pages?
Page 24. The typed copy.
25 is the original.
25 is the original. That was supplied to me by way of an RTI, your lordship.
Where's your name?
At page number 25. Lordship will see the school at second school, your lordship, Ravin Bora. First one is another school, your lordship. It is the second school, your lordship. Below column.
See it.
Therefore, I have given a typed copy at page 24.
Sundarpur.
Sundarpur border MH school.
Sundarpur border.
The second one, your lordship. First one is some another MH school, your lordship. So Govindranath Bora is the first teacher. Hello. Yes. So you know, format that has been given to RTA reply. Govindranath Bora is number 1, your lordship, and second is the name of Ravin Bora.
Okay.
And in fact,
petitioner is Robin Bora.
Ravin Bora. And in fact, your lordship, that matter has been informed by the block elementary education officer also at page 29 to the district elementary education officer saying that the name of Ravin Bora was recommended.
Page
29. This was the letter by the block elementary education officer to the district elementary education officer. Missing of the name of the founding teacher of the school in the list of provincialization. With respect to the subject cited above, it is to inform me that this office forwarded the list of the following teachers mentioned below for the purpose of provincialization of Sundarpur Border ME School. But the name of Sri Ravin Bora, which was sent by this office, has not been included in the provincialization list for which he has filed an application. In view of above, the matter has been forwarded to you for appropriate action. So as per the BO, he has forwarded the name of these 3 teachers. And pursuant to this letter, your lordship,
the DO at page number 31 had forwarded the same to the director.
Yes.
Page 31, after the getting the letter of the block elementary education officer, the district elementary education wrote a letter to the director, wherein the letter of the BO of the at serial number 2 reference, this was the letter of the BO in respect of the petitioner. So that in that letter, the direct elementary education officer has written with reference to the subject above, I have to honor to forward here 3 numbers of application received from the BO Demaji and Srimati so and so. That madam, I'd like to state that the report of district level scrutiny committee Demaji had already been submitted to your good office by this office letter number so and so dated 8/12/2017. All the petitioners were recommended as tutor in their respective schools. This is for favor of your kind information and necessary action. So his name was duly forwarded, but the name of the respondent number 6 was provincialized, leaving the petitioner who is junior to the petitioner by 16 years. And in the impugned order, what we have got is that this is a very casual order, your lordship. Even if district scrutiny committee has not recommended, then they ought to have find out the reason why the senior most teacher was left out and the junior teacher was provincialized. But the impugned order says that since the district scrutiny committee has not recommended, which is in fact contrary to the record, your lordship, they are not considering my case.
Yes, Kaushik.
My lord.
It appears that there was no application of mine.
My lord, but one thing, my lord, page 25, the lordship will see, his ad-based claim would be against the Govindranath Chandra Bora. Because he.
So
happens to be-
whatever it is,
My lord.
whatever it is, director rejected the case of the petition on the ground that the
It could not have been done in this way, my lord, that it ought to have done, send it to the district scrutiny committee for verification. Because the the appeal, the state level scrutiny committee has the power to call for the records from the district. And to examine if the district scrutiny committee has not recommended it, it was their role to say why the district scrutiny committee has not recommended. Instead of saying that the provincialization is rejected as it is not sent by the district scrutiny committee.
district scrutiny committee has given its recommendation.
But page 25, my lord, just a moment, your lordship will see. It, though it is, the petitioner says that he has obtained through RTI, but this district scrutiny committee report, my lord, does not bear any of his signature, the committee member signature.
How about the block elementary education officers letter?
Block elementary education officer has said that his name was sent, but it has not been included in the district scrutiny committee. But that goes contrary to page 25, my lord.
No, not his service was not provincialized.
No.
That is what he said. Has not been in the provincialization list. He has not said anything. And in fact, the letter of the DO also says that then petitioner's names were recommended by the district scrutiny committee. Page 31.
They were recommended.
But the page 31 does not indicate that his name was.
No. The BO.
I just read page 31.
I am reading it.
Yes. It says, I would like to state that a report of DLC Dhemazi had already been sent by to your good office. So and so, all the petitioners were recommended as tutor in their respective schools. Now, my lord, if you're also find page 25, madam.
Yes.
My lord will see down below, my lord. There's no signature of any of the members of the district scrutiny committee.
Then you produce
I used to. District-
the recommendation of the district scrutiny. Let him produce, then heard Mr. Ramesh Laskar, learned counsel for the petition. Mr. B. Kaushik, learned standing counsel,
Elementary.
elementary education, shall produce the recommendation of the district scrutiny committee with regard,
Sundarpur border ME school.
with regard to the Sundarpur
Border ME school.
Sundarpur border ME school
Sundarpur border ME school
In Demaji district.
in Hemadi.
in the of Dimaji district. When do you want? List after
2 weeks.
after 2 weeks.
Lordship may fix a date. Any
It
day.
will come, it will come.
Oblige Lordship.
Let's finish this. Last.
48.
May the lordship. Lordship, this is a petition for compassionate family pension lordship. Compassionate family pension lordship. Lordship, the husband of the petitioner was appointed as a primary teacher on 5/2/21 lordship. Thereafter on 9/10/21 he died lordship. Lordship, the respondent number 5 file additional affidavit opposition lordship. And I have gone through this lordship. Kindly, my respectful prayer is that lordship kindly withdraw this petition. We will go for lordship appropriate remedy lordship because of this affidavit lordship.
You want to withdraw
Yes, lordship.
with liberty to approach the appropriate forum?
Yes, lordship. Yes.
Then
Yes.
I'll dispose it on.
Okay, lordship. Yes.
Where is it? What have you stated? What ground have you taken?
My lord, here petitioner is not entitled to compassionate family pension. My lord, he was appointed as a tutor, my lord, not as teacher. my lord. After being a tutor, he is entitled to, my lord, benefit of compassionate family pension. So he is not getting anything.
Then what appropriate forum you want?
Lordship, we will file, we should be for ex gratia lordship, that is ex gratia. This is not very lordship for compensation before the
Ex gratia.
ex gratia, yes, lordship. We will file a petition because
Then
husband of the petitioner were
you want to file afresh,
yes, lordship.
not before the appropriate forum.
Forum, yes, lordship.
So let him withdraw it.
Yes, ex gratia.
Executive, we cannot, my lord, because he here, my lord.
Let him file, we'll see.
My lord, my
If
lord.
he's
My
entitled,
lord, my
we'll
lord,
get, if he's not entitled, we'll
my
dismiss.
lord, my lord.
Mr.
Yes, Islam lordship.
S.
Islam.
Learned counsel for the petitioner, press for withdrawal of the state petition with liberty to file afresh. Mr. P. K. Bora, then standing counsel, elementary education,
So respondent number 1, 5, and 6.
repairs for respondents 1, 5, and 6. Mr. D. Bhattacharya, then standing counsel, accountant general for respond number 3. Chalia, you are appearing? Eight. Chalia, then standing counsel, finance. Appears for respond number 2. And Mr. B. Deori, learning government advocate, appears for responder number 4. The petition is dismissed on withdrawal with liberty as paid.
Okay.
66 of supplementarily order.
What is this IA?
Lord, Lordship will remember, my lord, on the last occasion, I'm praying for declaration of the results and giving the provisional certificate because the petitioners or applicants, they already got the campus placement and they are likely to join one of the petitioner. That is the petition number 1. She is likely to join first week of June and others in first week of July. So I made a prayer before your lordships that they appeared in the final semester examination, So the results of that examination, page 21, my lord,
Of your IA.
of my IA, my lord. Declare the results and grades of the applicants.
Page 21.
21 of the IA, my lord, my prayer.
Yes.
Grant leave and direct the respondents to declare the results and grades of applicants in end semester 8th examination for BTech Electronic and Communication Engineering, as well as grant them provisional degree of BTech pending disposal of the writ petition. Because my submission is that, my lord, tomorrow, if the writ petition is allowed, then, my lord, if they lose this opportunity, because those companies are not before your lordships, this honorable court doesn't have any control over those companies. Wherein, my lord, we got our placements, we jobs. So, my lord, if any decision comes in the writ petition, my lord, then we'll be seriously prejudiced, my lord. If the writ petition is allowed tomorrow, my lord, there'll be, if we lost this chance of placement in the companies, my lord, we'll be seriously prejudiced. That is our case, my lord. And if the writ petition is lordships pause the query, my lord, on the last occasion, what will happen if the writ petition is dismissed? So if the writ petition is dismissed, their impugn order is upheld, my lord. And if the impugn order is upheld, our degrees, whatever the final semester results, those are gone, my lord. We are failed in the final semester exam. So that will be the outcome. In no way, my lord, the IIT is going to be prejudiced, my lord. The prejudice will cause to the petitioners, my lord, if they lose this chance. And IIT is not going to give, my lord, any other placement. Their own guideline says that they'll give placement only once. That was precisely my case. My friend has filed an affidavit. Perhaps he would like to, my lord,
Where's the affidavit?
My lord, it is there.
press his affidavit. Thereafter, my lord, if required, my lord, I'll submit, I'll give a preliminary reply, my lord.
Lord, if he has to say something on my affidavit, then I can reply.
No,
to
it
that.
is his affidavit, my lord.
And
He
I'll-
should place it, my lord.
I've already, it is there in the record, my lord.
So he should place his affidavit, my lord.
My lord, the case which has been made, try to make out here is this, that there is some kind of an urgency because these people have got a placement in some company, and those dates are apparently on June 1st, we can do something July. My lord will recall, on the last occasion, I had pointed out from the record itself. If record, my lord, I'll take it, this quote again to that record, that first and foremostly, with regard to the petitioner number 1, there is no record which suggests that she is going to join on June 1st. With regard to the petitioner number 2 and petitioner number 3, petitioner number 2's offer letter has a condition. Firstly, he is supposed to join from July 1st. Secondly, there is a conditional statement there in the offer letter that my lord will find in page number page number 41, my lord. That offer letter, which perhaps been relied upon by the petitioner to make it a case that there is some kind of an urgency. My lord will see in the note portion of that offer letter. It is after that point number 4, 2 passport size photograph, then there is a note. My lord has got it? Yes. In case of any deviation from information provided, then there is a line start, please be informed at the second line at the last. Please be informed that we are allocating the dates of joining based on our business requirement. We will send a joining communication at least 2 weeks prior to your joining date. So, this joining date of 1 July 2024 is a tentative date. It is a mutually agreeable date. It can be changed depending upon the business requirement of the company which they are placed. And it can be altered also. It is a private contract between them and the companies. And that can be, to my understanding, that can be altered. With regard to, my lord, the petitioner number, applicant number 3, his offer letter, my lord, will find in page number 44. My lord has got it. My lord will see
your joining date, the paragraph's last, the first paragraph, your joining date will be mutually agreed upon date. Kindly let us know your availability. So with regard to petitioner number 3 or the applicant number 3, my lord, the date is, their case is a mutually agreeable date. Hence, there is no urgency, it can be altered. Thus, the argument which has been canvassed here, that please intervene, otherwise I will lose out an opportunity to join this company.
About petitioner 1, applicant 1.
There is no record with regard to petitioner number 1. To my understanding, I may stand corrected if it has been pointed out.
Where's your offer?
My lord, I have made categorical statement on oath.
No. It may be a statement, but then there should be an offer letter.
My lord, the offer letter at present the company has given is this, my lord. Lordship will find page 40. It doesn't specifically say that I'll have to join in the month of June, but I am in talking terms with the company, my lord. IIT doesn't have any idea what is going on between me and my offer giving company. It is the instruction of my company that I'll have to join by first week of June. That's why, my lord, at para 15 of the IA, I have made categorical statement with regard to petitioner 1 that she'll have to join on first week of June. I could have said for petitioner number 2 and 3 also first week of June. But I have placed the correct facts before your lordships. What is the instructions from my client on affidavit? Para 15, my lord will kindly take up of the IA.
However, my lord.
One second. Sure. Para 15 of the IA, my lord, she has stated on her oath. Two and 3 July, my lord. That is my instruction. And I am in talking terms with my company, my lord. I am communicating with my company. They have conveyed me that you'll have to join first week of June. So for as petitioner number 1.
See, you have stated the offer letters issued to the applicants.
Yes, my lord.
By the respective companies mandated for their joining starting from first week of June
July,
for
June,
applicant number 1. Where's that offer letter?
My lord, that offer letter is not there, but this mail is there. They give email, my lord.
No, where in the email?
Email doesn't say.
Where does it state that
No.
the applicant has to join by first week?
Email doesn't say, my lord, with all due respect, but it is my categorical instruction. That's why, my lord, I have placed on affidavit. That's why I have stated on affidavit.
On your affidavit, you said that you have been given offer letters.
Yes, my lord. I have given.
Where's that offer
My lord,
letter?
offer letters are with regard to petitioner number 2 and 3, my lord.
You read it properly.
Yes.
You have made a wrong statement.
That the applicants would be joining in their job clearing end semester exam. The offer letter issued to the applicants by the respective companies mandated for their joining starting from first week of June for applicant number 1 and first week of July for applicant number 2 and 3. Therefore, non-declaration. Yes, my lord. I stand corrected. The document that I have annexed, it's a mail, my lord. It's not an offer letter. It's not an offer
Where's
letter.
the offer letter? You have said you have there's an offer letter.
Yeah, I stand corrected. I
Read
beg.
the offer letter.
My lord,
Then
till date, they haven't given the offer letter, but it is an intimation from the company that I'll have to join by first week of July. They don't say that on 1/6.
July part.
Sorry,
the sec-
first week
the-
of June. I'm
the-
sorry.
the-
For the company doesn't say that on 1st of June itself I'll have to join. They have informed me that I'll have to join on first week of June. So far as petitioner number 1. So far as petitioner number 2 and 3 is concerned, I have annexed the offer letters, wherein, my lord, it is specifically stated, my learned friend has not mentioned that, page 41. If your lordship see, we are pleased to offer you a role of graduate trainee engineer from 1st July 2024. Note will come later, page 41, with reference to your application and subsequent interview you had with us. We are pleased to offer you a role of graduate trainee engineer. That is, my lord, what we are to join as graduate trainee engineer from 1st July 2024. Note will come later, my lord. And so far as petitioner number 3 is concerned, page 42, my lord, will kindly see. Same mail, my lord. email. Also note that your joining date will be 15 July 2024.
That's fine.
This
So
is,
far as petitioner 2 and 3 are concerned.
yes, my lord,
This court is satisfied.
my lord.
So far as petitioner number
One is concerned, my
you'll
lord,
have to satisfy this
I
court.
am unable to, my lord, place any concrete, my lord.
Because the email which you have placed before this
My lord,
court.
Lordship will appreciate one thing. I understand, my lord, there is no clarity in the email, but I have made, my lord, statement on oath. I am praying for
Statement on oath also is wrong. You're making a wrong statement.
No, I state, my lord, Lordship will keep the offer letter portion away. Keep aside.
How can I keep it away when it is on oath?
No, I'm not saying that, my lord. Lordship will keep it for petitioner number 2 and 3.
Hmm.
Their joining starts from first week of June for applicant number 1. So it's a statement that, although it's not very clear, my lord, but it's a fact and it's my instruction also that from first week of June, the petitioner number 1 has to join. In the meantime, from Monday to Friday, my lord, I asked my client also that you give me some document by which I can substantiate before the honorable court. They have said that they will finally issue the offer letter and she'll have to join within a period of 1 week or so, or within a period of 3-4 days. That is my instruction, my lord. That is precisely my instruction, my lord. And I am in talking term with the company, my lord.
No, that's fine. That's fine.
The petitioner will have much idea regarding their joining, my lord, vis-a-vis the IIT, my lord, because after
See,
the,
Das,
I'm
the
sorry.
issue is this. They'll give you the offer letter.
Yes.
They will give you the offer letter. They will not say, come and join tomorrow.
No. They'll give you buffering time. My lord, keeping aside everything, my lord, for all the petitioners, what my prayer is that, my lord, their entire career will be at stake. Their entire career will be at stake if the results and the my lord, provisional certificate is not given to them. And they will be remediless after the writ petition, my lord. That is, my lord, precise case. Whatever be the joining date, whether it is June, mid-June, whether it is end of June or it is first week of July, that will be there. It may get postponed also August. I am not on that, my lord. But today or tomorrow, they'll have to join their job and they cannot join their job without their marks, without their results and their provisional certificate. That is my prayer before your lordships, my lord. Because tomorrow, if this honorable court hears the entire writ petition and come to a decision, my lord, that yes, this impugn order is bad, I'll be totally at loss. My lord. This 20-21-year boys and girls, my lord, they'll be totally at loss. And so far as our placement is concerned, my lord, IIT has no role to play as of now. We are already out from IIT. They themselves have said. So their own policy says that only one placement they will give, nothing more than that. So my humble prayer before your lordship is that lordship will be pleased to save these boys from losing their career, my lord. Nothing more than that. If after disposal of the writ petition, my lord, or at the time of final hearing, lordship finds that there is no merit in the writ petition, lordship will dismiss, upheld the impugn order, and whatever certificates issued to us, those will be cancelled, my lord. We'll thereafter also we'll lose our job, but pursuant to a process, a judicial scrutiny by your lordships. But now, my lord, lordship will kindly appreciate. At least this honorable court, my lord, give me that much of protection, my lord.
If I may, my lord. If I could understand the point which has been argued here is this: a public law remedy has been sought based upon a private contract. If the argument number 1 is this, there is a private contract between the parties. They are approaching this honorable court under public law based upon a private contract. So my lord should not look into this at all.
No.
This joining issue, my lord.
Let us not look into the joining issue.
Let me then on that case address this issue why IIT cannot issue this. And probably why my lord will have some difficulty.
The eighth semester, isn't it?
8th semester, final semester.
Final semester. Results have been declared for the others?
Others declared, May. 17th of May, others results have been declared.
My lord, on that case, my lord
Our
will take up
results-
my rules for a moment, my lord. I'll demonstrate why it is difficult for IIT, because the process followed in the IIT, it is not like in other universities which they follow. IIT has a continuous evaluation process where a student, because my lord, please appreciate, these students come from a same top-notch class of the people who in the India. They are not judged on basis of 2 exams. They are judged continuously amongst their own peers. So what IIT does is that IIT has a continuous process of evaluation. They will have unit tests, they will have this projects, evaluations, and other things, plus midterms and end-term. What the petitioner here is not stating specifically is this, that they have not participated in other continuous evaluation process. They have only participated in one part of the one of the component of the assessment. My lord, on that case, we'll take up my affidavit for a moment, my lord. I have clearly stated in my affidavit. My lord will see in my affidavit in page number 55, my lord, paragraph number 4. Let me just read these 2 paragraphs and I'll show the law also to my lord, how this thing has been done. My lord will bear me for a moment in this.
Yes.
The deponent back at the outset begs to state that IIT Guwahati follows and continuous assessments of students' performance throughout the semester, and grades are awarded by the teachers, course instructor, by the appropriate committee based on various parameters, and assessments have respective weightages. Final results are declared by evaluating all such assessment and parameters which a student is required to pass through during the semester. A brief summary of continuous evaluation process adopted by the IIT Guwahati for assessment of performance of the students is provided here under below. Every student is required to register for a prescribed courses through the assigned faculty advisor at the commencement of the semester. Students B are required to attend all classes, lectures, tutorial, studios, laboratory, and practical workshop, etc. for each courses which they have registered. For every course, there will be continuous assessment of the performance of the student throughout the semester as deemed fit by the respective course instructor.
Okay, let us do one thing.
My lord?
Let us do one thing. Is the main writ petition ready?
My lord, I have to file an affidavit there, my lord.
This is the problem. We can dispose of the whole writ petition.
1 month back notice
My
was
lord-
issued, they are staying. My lord, the concerned persons were not there. But my lord will grant me just 2 minutes time, my lord.
You file your affidavit by Monday, Tuesday we'll take up and dispose it.
My lord, if not Monday, Tuesday, my lord will give me a week's time. My
No,
lord,
no, week's time it will be too late.
my lord, in this week, I'll just one sentence, my lord, my lord will turn to page number 58, my lord, for a moment.
I'm on page 58.
58, my lord will see the table is there. Now, in that table, my lord will see these 3 people have various courses. So, see, for example, my lord, fuzzy logic and natural neural networks is the name of the subject. In that subject, there was quiz 1, which contained 10% of the weightage, quiz 2 has 10% of the weightage, midsum exam had 30% of the weightage, and some exam has 50% of the weightage. So, what had happened here, that these people have only appeared in the end semester. So they do not have marks for this other assessment. Our rule does not permit, my lord. I will demonstrate. My lord will take my rule, which I had given on the last occasion, and we'll see 17.1 for a moment in this case.
Which rule?
My lord will see there is a BTEC. So BTEC B- ordinance regulation. My lord will see, yes. Assessment in my lord will see 17.1. 17.1 for a moment. Then I'll.
Yes.
In assessing the students' assignment in subjects, theory, laboratory, studio, and seasonal, semesters, project work, etc. The system of continuous assessment is adopted by the institute in conformity with the practice. There will be one mid-semester examination and semester examination for every theoretical subjects. In addition, the instructors' assessment and quizzes, etc. Student 17.2. Student may be debarred for appearing in the end semester examination due to following reasons. They mention the reasons. Now, my lord will turn to 15.1, a page before.
Yes.
A page before, my lord.
15.1,
আগৰটো কিমান পৰিছিলে? আগৰটো কিমান পৰিছিলে clause?
17.1. 15.1. There will be continuous, it is under the head of assessment of performance. There will be continuous assessment of students' performance throughout the semester, and the grades will be awarded by the teacher concerned on the appropriate committee appointed for this purpose on the following basis. In case of theoretical subjects, evaluation will be on the basis of instructors' assessment, quizzes, mid-semester examination and end-semester examination. Seasonal subjects, such and such process. B, evaluation of project work will be based on seasonal work assigned by the superior. In case of other requirements such as C, in case of other requirements such as seminar, extra academic activities, etc., evaluation will be determined by the grades awarding authority. My lord will turn overleaf.
See, council,
My lord will come to E for a moment, my lord.
if we go by the procedure that you have prescribed for the assessment of the students, now they have not appeared in the midterm semester and
Before this court also, my lord.
what they have done is they've just in the end semester they have appeared,
Yes, my lord.
which provides only for 50%, correct?
Not for all courses, my lord.
Not for all courses, but whatever it is, according to this 17.1.
My lord.
Where's the 17.1? No, not 17.1. Where's that?
15 point. My lord, 15.1 talks about the pattern. 15.E, 1E talks about the weightage assignment by the teachers at the beginning of the semester.
So all this they don't have. Correct.
They did not participate in the, thus IIT could not, at this point, IIT cannot award them provisional mark sheets also. Because they are, apart from the fact that they have been expelled, they have not participated.
So they have not participated in all this test. Let us put it in a simple manner.
My lord.
Except in the end semester.
Yes, my lord.
Now, if you declare the results, the result will be on the basis of the end semester only.
Yes, my lord.
Not the other test. Correct.
End semester result
Obviously, they will not qualify.
End semester result we can declare, my lord. But what he is seeking, it is little, if I understand correctly, it is little different. He is not seeking declaration of end semester result, my lord. If he is seeking declaration of end semester result, it is separate, my lord. What he is seeking is issuance of provisional mark sheet. That is governed by.
So you declare the end semester result.
That I will declare if the.
Then after that, we'll see whether for the provisional certificate that we'll consider next week.
The marks will declare the marks which they have got in the end semester result.
Yes, you declared by tomorrow.
My lord, by Monday we will declare the results.
Monday we'll declare, we'll take it up on Tuesday, then we'll see what happens.
We will allow us to go to file an affidavit in this case, my lord.
No, that I'm permitting you. First, you declare the results. We'll take it up on Tuesday.
No, marks we can declare, my lord. No certificates or any grade cards will.
For that certificate, after you declare the results, then this court will consider whether the certificate is to be issued or not. You declare the results first.
The certificate component, my lord, has other components also.
That's why that part we're coming later. What we are saying is declare its end semester results now. Then we'll see what is the difficulty there. That you can do it. You can do it by tomorrow.
My lord, tomorrow is not working.
Tomorrow is not working.
Saturday is not working.
Okay.
Fifth Saturday. Fifth Saturday.
IIT does not work on.
I'm sorry, I don't know. I'm sorry.
No problem.
My friend may be correct, my lord.
My lord, if my lord allows me, I'll come with an instruction and probably 2 minutes later I will place it. My lord will just give me 2 minutes and let me just stick with the person concerned. Can they declare results on?
But if not tomorrow, my lord, if they have difficulty on tomorrow, Monday first half also do, my lord.
My lord, let me just get back to my lord. Will get me just 2 minutes of time. I'll get back to this court.
Call up the other.
61 of supplementary list admission.
Question matter.
May pleasure lawsuits. In this case, I have filed one IA, my lord. This honorable could pass an order, my lord.
My lord, the matter has been, my lord, listed in the admission column and the order has been passed, my lord.
IA?
Actually, admission is given, no?
He dilemma, I had to get for book and I said.
I had admission of this, I haven't get.
We have said that the main writ petition should be heard.
My lord, in this case, they have filed affidavit, my lord, let them argue first.
Which one?
In this case, my lord.
In the main writ petition.
Yes, my lord.
Have you filed your affidavit?
No, no, my lord, he has filed affidavit.
You're not filing affidavit?
No, my lord. I have come for IA, my lord, because to get the order of.
No, that order was already passed on 10/10/2023.
It is
Have you got an order? Have you got a copy of the order?
for admission hearing.
How we have been heard to the contribution awareness?
Oh.
Entire matter should be heard on merits.
Oh, I have no knowledge, my lord, because I was not there, my lord, at that time.
So,
I went to Delhi for my treatment. That
so entire matter should be heard on merits, so you may have to file your affidavit in the writ petition.
আমি affidavit দিয়া নাই নেকি? এই শুধু রিয়েক্ট ছিল।
I had to.
No objection filed. Yes, my lord, I would like to file affidavit, my lord. I was not aware, my lord. I was not aware.
Mr.
Bigger.
Counsel for the petitioner, MSK Devi. Learned counsel appearing for the respondent number.
Respondent number 7. 7.
7. In the main writ petition. Praise for how much time you require?
1 week, 1 week.
Praise for 1 week time. to file.
No, 1 week, I wouldn't.
Praise a lot.
It may be fixed for hearing, my lord. 10, my lord, 10 June.
My lord, later file, my lord, 1 week, then, my lord.
Okay.
Because I have some, my lord, after 1 week, I have some difficulty.
I have asked my.
What is the court time? I forgot the court time. Don't worry, I'll check up your matter.
62.
May pleasure.
Yes.
In this case, your lordship, by order dated 17/5/2024. 17/5/2024, your lordship. Last part, your lordship, in view of the order, the registry was directed to arrest the Department of Education Secretary and Commissioner Party. But in fact, I have verified the records and office note.
Yes.
I have verified the office note that there is a notification of this court
Yes.
that handwriting is not allowed, that we have to file incomplete.
Yes.
By Monday, I will file your lordship. I can take up the matter on Thursday or Friday.
Okay. On request made by Mr.
Yes, Islam. Your lordship.
S. Islam, learned counsel for the petition. Release the matter on 10.
7 or 6 or 7, your lordship.
7 may not be possible.
Because there is related to pension of the mother, your mother.
6.
6 years. Obviously.
66.
My lord,
60.
my lord, for a moment.
Lord, one contention has been said by my friend that from January to June, we did not participate in midterm. We did not give assignment and quizzes. I have given my lord documents wherein they have submitted their assignments and quizzes. And midterm examination, we were kept under suspension.
So you will suspend us and you will say that you did not appear in this. How far that is?
Yes, any instruction?
My lord, yes. My lord, now vacation is going on in IIT, my lord. The professors have gone out. So what they have told me is that because these people are expelled, so result cannot be declared. But in the seal cover, probably on Friday, they can give the marks. On a seal cover for the court.
No.
Yeah. Because the professors are out, my lord, that the IIT is now in vacation. To contact the this invigilators and do that. They are saying by next Friday they can give these things in a seal cover because these people are expelled already. The results cannot be declared. We can give it in a cover and probably the my lord can pay with an
By when?
Friday, my lord, next Friday.
Lord, one thing I'd like, one subject to what my, it's an IIT, my lord. Everything is done nowadays online. Even if we submit our papers also through online, teachers are not there, my lord. If they have evaluated the, my lord, answer script, where is the question? My lord, it has to be declared, my lord. People has to find it.
My lord,
The student has to find it. What is the seal cover business,
my lord, if it is, I'm not sure it has been evaluated or not. That, but to my understanding, they will be evaluating it because these people were expelled. Expelled students, they have been court had only allowed to appear in the examination. So what I'm saying is because these people are
So
already,
you are not sure whether the answer scripts have been evaluated or not?
they will be able, that is that part, my lord, they have not told me that. They just told me this, that the instructors are already in leave because of the holiday. They would have gone to some conferences to attend or their own work. So they said on Friday they can give it in a cover and they can do
No,
this
what you can do, we'll list it on Monday,
Monday next.
coming Monday.
I will file the affidavit also, my lord. by
That
this
is
time.
third.
my lord.
That day you come with proper instructions, whether the answer scripts have been evaluated or not. And then when you can pronounce the results. The time is short, so you have
Tuesday,
maybe,
my lord. If it is, I have some personal difficulty on Monday.
okay, Tuesday
Fine,
also.
fine, my lord.
You have it on.
And well, only two things, my lord. Only two submissions. There should not be any seal cover thing, my lord.
No,
I don't appreciate this. Number one. Number two is that, my lord, the honorable court, this honorable court, at the very beginning, when passed order, there was no direction by this honorable court not to evaluate. This honorable court directed not to declare the result. That much only. If they haven't done the evaluation, it is their flaw, my lord.
My lord, on that case, I would like to submit this, my lord, because these people were expelled. I would have shown from the rules. Once the students have been expelled and their registration is cancelled, IIT does not evaluate or does not deal with that student immediately. Because our rules says once the registration has been cancelled of a student because of a disciplinary proceedings, he is not to be evaluated anything for this particular semester.
Fine, in that even.
That is also there, my lord. That is
That will consider you take your instructions
on
properly. and
Tuesday,
come-
my lord, we can.
Heard HK does, then the council for the petition, for the applicants.
Applicants.
Stop. Mr. ABD,
My lord.
learned counsel appearing for the respondents. 2 to 7. Shall take instructions as to whether the answer scripts of the applicants with regard to the end semester, within bracket 8 examination.
My lord, can the my lord say when the results can be declared? Or that marks can be declared?
For BTech, electronics and communication engineering has been evaluated. And when the results.
Marks can be declared.
And when the.
Results, same thing.
And when the results can be declared.
Results are, they understand differently, my lord.
What is this, my lord?
The
Not
these people,
understanding.
IIT, they understand result as a grade card. The entire result of a
My friend is
you
there.
only see that
My
midterm result on that case. End term, my lord, I'll explain.
My able friend is here. We have to
I'll explain.
make them understand. Fourth one. Fine.
Fourth, you can upgrade the matter if.
I'll make a mention. I'll make a mention. Yes.
Deeply obliged.
Deeply obliged. Much obliged.
Extremely sorry for the delay.
63.
May I please, matter relating to amalgamation of two schools, my lord. Here the departmental affidavit is required, my lord. Till that no affidavit has been filed.
Yes, department, which department?
Elementary, my lord.
Elementary. PK Bora.
That order was given by the DO, my lord, to the headmaster of the amalgamated school to hand over the charge to the base school, but no charge was given. Thereafter, the showcase notice was given to the dead headmaster, the Mars school. Till date, no action has been taken. Your lordship will find the showcase notice, page 38. Page 38.
Yes, Bora, have you got instruction?
My lord, no, my lord, some time may be granted, my lord.
That is.
38. Yes.
Heard, Mr.
R. Islam.
R. Islam and Council for Mr. BK Bora, the Standing Council, Elementary Judicial Department. It's allowed how much time?
2 weeks, my lord.
2 weeks time to file contract. List of documents.
Deeply obliged.
Obliged.
My lord, item number 65, this is order matter, my lord. Today is the, my lord, 8 number of listing today, my lord, as in today, my lord. So, my lord, if the matter may be taken up on Monday as a first item in the order column, my lord. This item 65, my lord, order matter, my lord.
You want to take it up on Monday, that also you get your name, case listed as the first order matter? You want everything in your favor? Huh? We list it after 3 weeks.
Lordship, I'm sorry, my lord. If the matter is continuing, my lord, I'm here.
I'm rising already.
Lordship. Then, my lord, otherwise, my lord, this matter is listing, my lord, today is the 8 number of date, my lord.
Today is what?
8 number of date, my lord. 8 number of listing today.
Okay.
So this matter was filed for.
What is this for?
My lord, this matter was.
What is this IA for?
IA for, my lord, granting stay order, my lord. Stay against the, my lord, that order passed by the district elementary education officer, my lord. My lord, approving a school management committee, showing the respondent number 9 as the precedent.
Okay.
Whereas, my lord, the present petition was selected by the resolution by the school management, by the guardian of the school, my lord.
Fifth. On fifth. Okay. Or you want Monday?
Monday, my lord.
Okay.